Already dispute of the direction to appear for the accuracy symbol tomorrow.
Which matter? Court of what?
Yes, yes. Court of words, that Lal Chitaranjan. Yes.
It will be uploaded
Uploaded.
Today.
Okay.
It is going to be.
And
We are aware of that.
yeah.
Only one urgent tomorrow, Lordship. Kindly,
Please give
Lordship.
us if we don't know tomorrow or when.
The urgent matter, other infectious, Lordship. That's it. Tender matter.
Hello, the matters listed today is item 41. Can I request and pray before my lord to take up activity? I've taken.
What is the matter about?
My lord, the matter is about I own a land, and my lord, I had applied for a dealership, my lord, before the Bharat Petroleum. And previously, my husband.
No, why the matter should be heard today? That is the question. How urgent?
My lord, the urgency is, my lord, by the judgment of the honorable single judge, the Bharat Petroleum was required to give me the dealership, my lord. But the appellant has opted to stay out of my lord, and he is operating, my lord, on my land. And that is the urgency.
Have you filed any application for vacating the order of stay?
My lord, we have.
You have filed.
My lord, we have filed, my lord. I'll
Appellant is not a he, it is a corporation.
I'm sorry.
All right.
My lord.
We will see.
And my lord, this was already listed before your honorable court on Thursday, my lord. It was fixed at 2 p.m., but it cannot be taken up, my lord. Also, there was some personal difficulty. I only request it may be taken up today. Anytime.
We will try.
My lord.
If not today, we will see if it can be taken up tomorrow.
My lord. My lord.
If it is not taken up today, then you can make a mention at 4:15 or 4:30 when we rise.
My lord.
Item number 1.
I have approached them as your lordship, and they have placed all my materials, all the relevant. No reply has come from that side.
My lord, I am appearing for opposite part number 2 and 3. My lord, I have instructions that on 7/8/2024, the petitioner had come to our office for a discussion, and on that date, we had already made them clear that so and so was our proposal, and the petitioner has to take a call, my lord. So it is on them, my lord, to take a call.
No, I don't think, because we have not anything what your lordship, just to recapitulate, if your lordship remembers.
I remember.
The only question is they are now giving it as a lease, not as a sale. So what price would be fixed? But I am putting a question to myself, subject to your lordship's consideration, my lord. Suppose I vacate today. Tomorrow they will give it to X. Whatever price they will give it to X, I will put it. Why go into that controversy? Because they have a set of rules, because there is a public body. They cannot act like a private.
What about the time you occupied the property without utilizing it?
No, we have paid everything. Every rent, every
Up
due.
to date, till
Yes,
date.
till date. There is no arrear. And on the basis of orders passed by quasi-judicial authorities, we have proceeded. Not that on our own, on positive orders passed. So what I am saying, I have placed them that this is your rule, this is your yardstick, and this is your price. So I don't know, because my client says that they said that we will inform you later.
So inform him.
May
If there is any final proposal made by you or after he submitted his documents, or the petitioner submitted its documents, then give that. What is the proposal?
In that case, my lord, let the matter come next week. I will
Why
inform.
tomorrow?
To
Tomorrow, that everything is, and he is right in his submission that you are not. See, if you want to sell the land, then you can sell it.
But actually, my lord, my lords may kindly see order dated 1/11/2023, my lord.
23.
My lord.
Yes.
The third paragraph, my lord.
Yes.
Mr. R.K. Mahanti, Lanet, senior counsel, appearing for the petitioner, vehemently contended that bereft of the dispute involved in the present application. Now the opposite parties have taken a decision that in the event the party will pay the market price, my lord. So the petitioner agrees to pay the market price, my lord.
He is ready.
My lord. No, my lord, he is disputing that the proposal that we have given is the market price for sale, but he is ready to pay the price for lease. So my lord, he is not clear.
No, I am very clear. That is the document which I have given before the court as well as to them. That this is your price and this is your approved price. If your lordship kindly sees that affidavit also, I have given that document. That this is the price which they have fixed. I have not fixed for a lease of industrial area. And last time when your lordship heard that,
Do you want to sell the land?
yeah,
To that
and it
extent,
is the
my lord,
IPR policy also.
my lord,
That is the industrial policy resolution that they will utilize it for the industrial purpose.
my lord,
They cannot do that. It's not a private sale or anything.
my lord, let the matter come day after tomorrow. I will inform this honorable court.
As requested on behalf of the opposite party in court, notice this matter on Thursday.
Let them put it in writing so that I can know, because as my client says, after that, they said that we'll inform you.
My lord, in that case, my lord, because I will have to first
Your lordship may
seek
call
for
it next week.
information.
If he says that he wants, but let it be on record so that
Tuesday. So as to enable and counsel appearing on, so as to enable him to bring on record by way of affidavit the INCO's proposal for settlement of the dispute which the present proceeding involves.
I have given my documents and papers. Their
What is
documents.
their proposal?
Lordship is calling it
On Tuesday,
Tuesday. Interim order.
within interim order, retaining its position.
Item number 2.
Because they have given an offer, the LIC has given, we are making a negotiation about the payment schedule minors. That we may get.
Do it. Yes.
My lord, we have already indicated in the last occasion that the best price should be 71,85,000. So this is the best price, my lord. There is no scope for.
But
any
I want that
negotiation.
we are negotiating for payment
There is
schedule
no question
minors.
of a negotiation. This is the best price because as your lordship's direction, I have already, with the instruction of the.
So you will pay 71 lakh in one go.
That he has to, as your
This is
lordship
what
may
they are
direct,
doing.
whether it is the installments or the.
This is what they are, so about on amount, there is no dispute now.
My lord, that is exactly. my
Only the
submission.
payment schedule, because that is.
Do it fast. When?
Minus 10 days time, because that's a huge amount. I have to take a payment schedule. I'm negotiating with the LIC for the payment schedule.
Petitioner states that steps are being taken, through negotiation, to decide the payment schedule. So stop. List this matter on 2 weeks, retaining its position. Please do it.
Yes.
And please, yes.
Item number 3.
Item number 3, that is regarding loss of fire matter. I heard last occasion on 4th that I should give the documents. Why the fire certificate is essential? I have collected all the documents and I have made an affidavit because the holidays that could not be shown. So tomorrow I can file.
What cannot be shown?
My
Oh,
additional
that could not be
additional
shown.
affidavit regarding the how the why the fire certificate is essential, for what reason?
No, for what reason? Reason all of us know that why
But
there should be fire
the
safety.
Odisha Fire Safety Act and the regulations, that is provided, I have got it.
No, but whether your regulations require,
No, the INC regulation also says there should be fire extinguishers.
say that.
Yes.
Where is
that-
that INC regulation?
Yes, that I can. So that's why I wanted to give an additional affidavit so that I can clear it.
You're saying affidavit is ready?
So I have sent it for vetting there because two holidays were there. Today it has opened.
So you have mentioned in the affidavit that
Yes.
the INC
Yes,
regulations
yes.
also require.
Yes.
INC regulations only require fire extinguishers, then there
Yes.
should be no problem.
Fire extinguisher they want. And our government.
See, there is difference.
Yes,
If there is
extinguisher.
any statutory requirement,
Only for the.
that there should be fire certificates, fire safety certificate issued by the authorities.
Yes, ma'am.
Then, yes.
My lord,
But if certain compliances are required to be carried out, then certificate is not required. You have to ensure whether
my
the,
lord, INC in GNM courses, they have given for extinguisher. For all other courses, they have not defined anything. What I have studied, and for the state government.
please try to appreciate this, that there is difference between mandatory requirement of fire certificate, fire safety certificate, and availability of the equipments or things to ensure fire safety.
Yes, ma'am.
These are two different things.
Yes, ma'am.
So only on the ground, say if they say that we have everything to ensure fire safety, but we don't have certificate, can you reject?
So unless the fire certificate is there, they have to give the certificate. Then mandatory provision of the state government has made it. Because the regulation and.
That is why we are asking, is it mandatory? Show us that
Yes, ma'am.
regulation.
That is
where-
been written. And
Mandatory in your regulations,
Yes, ma'am.
not in the building regulations.
The building regulation, they don't have the plan. That is the why they have rejected fire certificate. Building plan is not approved. That's why the fire certificate is not given to
That
them.
is okay. What is being asked is whether your rules provide mandatorily
All
for
right,
us fire
all right.
safety.
Another question.
Yes.
So whether it is mandatory that building plan must be approved
Yes, ma'am.
for granting NOC,
Yes, ma'am.
that will serve the
Yes,
purpose.
yes, ma'am. That is.
Because building plan
That is there
cannot
in
be.
your
Yes, yes,
regulations,
yes.
building plan approved.
Yes, madam. What,
Building plan, the building plan requires fire safety certificate.
And
That
also-
cannot be granted.
my lord, and also the state government has made the regulations again changed. That the old institutions who are not having this building plan and everything, one time they have given us
We will
agreement.
examine,
Yes, yes.
we will examine. When do you want?
Next week.
Next week. And what is the last date of admission?
Admission is 30th of September.
This will have to be expedited now. Yeah, this is, today is 10th.
No, we'll keep to next week. You will say I filed, it will not be there on record. It will again be adjourned. That is the
It will come
problem.
on Thursday.
You are saying it is ready. Okay.
It will come on Thursday.
Mr. Mohanty and counsel appearing on behalf of the BMP. I submitted that. An additional affidavit is going to be filed to demonstrate that an institution must possess fire safety certificate relating to its building or grant of NOC / renewal of NOC. So stop. Let. Today you will file?
Tomorrow I will.
He states that the affidavits shall be filed by tomorrow. So stop. List this matter on Thursday. Retaining these matters on Thursday, retaining their position. Stop. The registry is directed to ensure that the additional affidavit, if filed by tomorrow is placed on record on the next day.
Sub-item to your lordship. Item three, sub-item to fire safety certificate is there, your lordship.
In this case, fire safety certificate
Yes,
is
madam.
there.
We have found on 26th of June, he has filed a fire certificate. But once that is been there, we will allow him for NOC. Previously, it was not there.
Consider his case in the
Yes, sir.
meanwhile.
That we will consider.
180.
But why didn't you file your certificate while making your application? Your certificate was issued in April 2024.
After the deficiency complied, when they given the letter of a deficiency, I have complied all the deficiencies and giving undertaking that I have applied for fire safety certificate. Whenever it come, I will produce.
Adds regards. WPC number
18413.
18413 of 2024. It is the petitioner's case that the concerned college, does have fire safety certificate issued by competent authority, which has been submitted to the DMET.
Yes, yes.
Submitted to the DMET in response to the deficiencies pointed out by the DMET for grant of
NOC.
for renewal
Renewal of
NOC. It is expected that when counsel for the DMET shall take instructions in this regard and make his submissions accordingly on the next date. So if you can do it, do it.
Yes, ma'am.
I will keep it pending. If they
No,
choose,
better.
then we will dispose.
My lord, item 21,
Yes.
the notching matter. There are 9 matters. They have 2 days before they have given me the copies. So let it come next week. I will get instruction and all stuff.
So now we should stop entertaining writ applications.
Yes,
What are they about?
Yes, ma'am. This is about that NOC. After cut-off date, the deficiency has been complied after the due time. That is pending tomorrow for adjudication. Most of the cases.
No, my. In that case, I have some of the application which has been filed by me. That application is filed on 1 to 2 of September, and already in the meantime, copy has been served on that day, on the date of the filing. Thereafter, now the lapse of 10 days after.
So what is the average time taken by the courts for disposal of a writ petition?
Now, the department has not.
Now
issued
you
any
filed
notification.
the writ petition on 2nd. Today is 10th.
Yes, ma'am.
In the meanwhile, there are holidays also. All right, we will see when the matter is taken up.
Yes, ma'am.
Item number 4.
Item 4, your lordships were pleased to hear this matter last week. Lords, it is that additional
yes.
qualification, your lordship, that
We will decide.
my lords. Lordships have heard this, as your lordship may decide.
What is the counsel for the petitioner and the state? This application is dismissed.
Item number 5.
Please, your lordship. Yes, the order, judgment of this honorable court as per Annexure 1, dated 5/7/2023, has not been complied till date.
Let us see.
That order starts at page 9. Operative portion is at page 36.
When was the order passed?
5/7/2023.
5/7/2023.
My lords.
What was the order?
My lords, the order starts at page.
No, no,
10.
what is the operative portion?
Operative portion is at page 36. My lords, it starts at para 45.
Yes,
May I read, my lords?
yes.
The cumulative effect of these observations is that The order dated 5/5/2012
So
cannot be
pension and
sustained.
gratuity has not been released.
Sorry, my lords.
What is the non-compliance?
Non-compliance is that there was a specific direction from this honorable court by that judgment to release all my arrear dues within a period of 3 months. And the language used is, we make it very clear. Lordship, may kindly, I'll just read out 3 lines from the last page, that is page 37, paragraph 48. It is made absolutely clear that if the payment is not made within the stipulated period, the petitioner shall be entitled to interest at the rate of 7% per annum from 5/5/2012. We also direct that if any other benefit such as release of increment, etc., is due to the petitioner, that shall be released and paid within the said stipulated date. Now, after that, there were some communications between the opposite parties, wherein they have admitted and they have said that they will pay. That is at annexures 2 and 3. But till date, my lords, since 2003, he was suspended and the petitioner superannuated from service from 1st of January 2007. Now, from that date onwards, my lords, I have not been getting pension and my retirement dues. So that is about 17 years down the line.
Yes.
Yes, I've got instruction. Yes, his suspension period has been now treated as duty, order has been passed. Increments have been all sanctioned and a sum of rupees 4,58,500 has been paid to him. And so far pension is concerned, he submitted all the pension papers and it has been forwarded to the office of the Accountant General, my lords. Now it will take some time. If your lords is direct, I can pursue the matter because it's the Accountant General.
And whether the 7% you have calculated?
Yes.
7% has been calculated or not?
That instruction I
that
will
you will have
take.
to do.
No, that we will do. We have to comply
Otherwise,
that.
we will proceed in this matter.
Lords, 2 weeks time. In the meantime, I will find out whether 7% interest on that increment has been paid or not, and about the pension was sanctioned or not, because it was submitted way back in March.
In the present contempt application, the petitioner has alleged deliberate disobedience of this court's order dated 5/7/2023, passed in WPC number 9788 of 2014, operative portion of which reads as under paragraphs 46 to 48. We'll stop. Next, Mr. Samantrel and counsel and AGA representing the contemners upon instructions has submitted that the petitioner's period of suspension has been regularized. We'll stop. Further, the petitioner has been paid whether
Lords, increments, lords, amounting to rupees 4,58,000.
Found to be entitled to, that has been paid.
That has been paid.
I have to take instructions in
Just a minute. The petitioner has been held entitled to benefits of increments, and the same has been paid to him. Stop. Learned counsel for the petitioner submits that he'll have to seek instructions as to whether the said amount has been paid or not. Stop. Next, as regards pensionary dues, pensionary benefits, learned counsel, learned AGA has submitted that the state government has issued sanction orders for payment, which has been communicated to the office of
Accountant General.
Accountant General. Where the Accountant General recently.
Lords, yes, Lords, 1 or 2 months back. Lords, recently.
Recently. Stop. He has, however, not been able to make any statement as to whether interest at the rate of 7% per annum as awarded by this court upon the petitioner's entitlement by this court has been taken into account for the purpose of computation of the petitioner's entitlements. So stop. List this matter on 2 weeks so as to enable learned AGA to file a so-called reply from. We are of the prima facie view that the opposite parties have flouted the court's order dated 5/7/2023 by not adhering to the time schedule as mentioned in the said order. So stop. The court will further proceed in the present matter depending upon the subsequent conduct of the contemners. This matter on 2 weeks, 3 weeks. Please in the meanwhile.
Yes. Retain its position will not specifically adjourn matter.
Make a mention. Make a mention if it is not taken up on the next.
Item number 6.
See, our approach should be that you get what you are entitled to in terms of the order.
Grateful. Absolutely.
It may be taken next week.
Why, sir?
Because I am not ready due to my illness.
Huh?
Due to my illness, I am.
Oh, your illness, all right. When do you want?
In the
Next
meantime,
week it may taken next week.
in the meantime,
Next
copy
week it
of the writ appeal and step petition may kindly solve.
Writ appeal and step
Copy of the writ appeal and the step petition.
As requested on behalf of the appellant, list this matter on. When do you want? 1
Next
week? 1 week? So stop. Let a copy of the writ appeal with stay petition be served upon Mr. Panchanand Sahu,
B. Pujari.
Vasudev.
Mr.
So on you or Mr. Pujari?
Vasudev Pujari.
Mr. Vasudev Pujari, learned counsel for
Opposite party number 3A and 4.
opposite party number 3,
A and 4.
3A and 4.
Respond.
Opposite parties or respondents. Yes.
Item number 7.
In item number 7, my learned friend who is appearing for the opposite party is saying again an incomplete copy of the writ appeal has been served to him. I'll serve in
It
course.
is stated by learned by Mr. Sir, what is your name? Mr. Amit Kumar Shah. So this is for all the members of the bar that I have very poor memory of names. So if Amit Kumar Shah, that an incomplete copy of the writ appeal has been served upon him. Top learned AGA representing the appellant states that complete copy of the writ appeal shall be served
in course of the day.
Shall be served upon him in course of the day. List this matter tomorrow.
Yes.
Mr. Kuntia, you check and give it to him in court today. It'll be better.
No, that is extra copy is not with me. I'll serve him in course of the day.
Check and
I
give it to
instruct
what-
my.
Yes.
Item number 8.
May I please, my lord? My lord, the order of the Honorable Single Judge under Annexure 1 is under challenge, my lord. My lord, what happened, my lord? In the writ petition, my lord, the order passed under Annexure 4 by the MSMED Council, my lord.
You are representing whom?
I am representing the distribution company, electricity supply company.
Just-
South TPSO DL, my lord. My lord, here what happened in this case, my lord? My lord, this respondent number 1, my lord. This respondent number 2, my lord, he has placed some orders for supply of materials to respondent number 1, my lord. And our purchase order was issued to respondent number 2, my lord. My lord, he supplied some materials to the my lord, and my lord, he filed a complaint reference before the MSMED Council, making all allegations that this respondent number 2 OSIC has defaulted in making payment, my lord. My lord, whatever work this OSIC has materials he has supplied, my lord, we have paid to him, my lord. There is no nexus with the.
but come to the order.
My lord, the order
says
is,
that
my
you
lord,
have-
Lord, you may see, my lord, the honorable single judge order, my lord, or the MSME order.
No, page 5, paragraph 5 of the learned single judge's order.
My lord, my lord. Paragraph 5, my lord. Section 19, my lord, above that, my lord.
Yes, let us see section 19.
If further that the contentions raised by the Lord Council for the petitioner requires factual adjudication by receiving evidence which may be possible in a proceeding under Article 226, 27. And there, my lord, 5, in paragraph 5, section 19 of the Act provisions efficacious remedy for the petitioner for redressal of the grievance. It does not appear that the petitioner is incapable of availing the remedy under section 19 of the MSMED Act, my lord. My lord, Lord, you may see section 19, my lord, my lord, MSC, when the reference is made under section 18, my lord, 17, then the council is bound to follow section 18 of the MSMED Act, my lord. Here, my lord, when the complaint was filed, reference was made against the OSIC, that is the respondent number 2, who has placed order to him to supply the materials, my lord, and the entire allegations is against him. My lord, that
Maybe
was not
against him, Mr. Counsel, but come to section 18.
18, my lord. Reference to Micro and Small Enterprises Felicitation Council.
So whether this has been done or not?
No, nothing, my lord. Neither
So
the
you should have done.
No, my lord.
Why did you
My lord, the
challenge
council is to follow. Council is to follow the procedure as laid down under regulation 18. But I may permitted to
So
place
you had just a minute. You had challenged the order of the council.
council, my lord. I had challenged in the council order is, lords may see, 1 page or 2 page order.
Just a minute. Just a minute.
The
just a
council
minute.
who was
Just
dead during the
a
corona.
minute.
Mr. Das, wait.
So, but this reference, this order has been passed under the provisions of Arbitration and Conciliation Act.
No, my lord.
No.
No, arbitration and conciliation proceedings were not followed as contemplated under section 18 of the MSMED Act.
Is there any decision of this court?
Yes, my
It
lord.
has been
Supreme Court
delivered by
decision is there. Direct decision touching on this point, my lord. My lord, Jharkhand Urja Vikas Lingam Limited, my lord.
All right.
My lord, Jharkhand Urja Vikas. My lord, here, my lord, what happened? The order of the MSMED Council.
There is a decision of division bench also of this court.
Yes, my lord. My lord, that is Bajaj Electricals Limited. Single
Which
bench
state?
decision I have got, and the Supreme Court decision is on this point. Jharkhand Urja Vikas, my lord. There was an appeal, there was a writ petition filed challenging the award.
Yes. All right. So, we are issuing notice. Issue notice. 1 week, 6 weeks.
Citation order लिखी हुई है कागज पे।
find out a decision of this court also.
My lord, I will try, my lord.
Pending decision. Appellant counsel appearing on behalf of the appellant has placed reliance on the Supreme Court's decision in case of Jharkhand Urja Vikas Nigam Limited versus State of Rajasthan and others. Report reported in so and so. In support of his plea that the Micro and Small Enterprises Facilitation Council has not followed the procedure prescribed under the Arbitration and Conciliation Act 1996 while passing 6, which is the mandate of section 18 of the Micro, Small and Medium Enterprises Development Act 2006. Top. He has accordingly submitted that learned single judge erred in directing the appellant to invoke section 19 of the Act to assail the order of the council. Stop. After having gone through the impugned order passed by the learned single judge and other materials on record, we find substance in the submission advanced on behalf of the appellant. Stop. Accordingly, we direct that the effect of the order dated 30/12/2020 passed by the council shall remain in abeyance in the meanwhile till the next date.
Lord, the execution proceeding has been filed.
The abeyance, that order,
Yes.
execution of what?
Execution of that order.
So that order has been stayed.
Yes, when the order is.
How can execution proceed?
Nothing is to be executed. Yes, my lord.
Item 9.
My lord, I am for the appellant. My senior advocate, Mr. D.P. Nanda, is out of station. So I pray 2 weeks' time.
We can adjourn, but you should not make any application for urgent hearing later. Is there an interim order?
No.
As requested on behalf of the applicant. Just this matter on 2 weeks.
Item number 10.
May I please?
I've been instructed to appear on behalf of the opening of school, state police.
What is this matter about?
But in this matter, my lord, Lordship's kindly, interesting changes of like a Damocles sword. I'll tell you, Lordship's what. The respondent number 3 is my adjoining neighbor. In the sense, he has a hotel at Puri, I have a hotel at Puri. The respondent number 3 made a complaint to the Human Rights Commission that, Lord, I fail to understand how Human Rights Commission can exercise a jurisdiction, making all allegations that, yes, one allegation is genuine, could be that I have got some pollution is being created by me on his campus, but that's not human rights. He can make it some other. And he also made a complaint that my land rights are nebulous, my other things, and like series of complaints. The Human Rights Commission directs all authorities of the state that you look into the matter, pollution to look into the matter, and the Human Rights Commission and the pollution look into the matter. And because the order is there, what they do, Lord, I have a, as your lordship, the law is, Lord, there are lot of laws which provides for deemed approval. In a sense, if you apply, you don't get it on time or not refuse in time, and it is deemed to have an approval. Development Authority, water, I have got a deemed approval. Because of the pollution, the direction of human rights, the pollution authorities directs me to stop construction. That is the starting point. I come up before a lordship, before the honorable single judge. Before the single judge, the same neighbor who has no locus standi raises all issues, including that my title is not imperfect, my inchoate, my other things. But it has to be confined to pollution. Pollution is confined to it. Because then the honorable single judge gets into all these matters and said, your title is void. But in a matter where I bring it to the notice that I should not have been stopped construction by the pollution, and then he said that my title is void because I'll tell you, these are also the title is void. These are not issues. Be that also, I'm prepared to explain to lordship that my title is not void, and he said that my title is void. The pollution induced stop and then directs it. And consequence to that, the pollution control also stops me again.
Just
Closure
because
of the honorable single judge order.
Just a minute, Mr. Counsel.
Lord, if lordship says.
No, but don't you have points against him?
Take a lordship.
Don't you have points against him? See, if there are, he is alleging violation of various.
But actually, the neighbor should be leave and let leave principle is not followed. We have a hotel, he has a hotel.
He has decided
and I have
not to follow.
rectified. I have rectified the other things. Not that I did not do any, if at all, mistakes. And the court, the honorable single judge directed that both sides should sit in compromise.
There is a leave and let leave. There must be something. Some saying just the reverse. डूबेंगे और
डूबेंगे उसको साथ लेके डूबेंगे.
Yes, we have one crude one in Odia.
All right.
How can they respond?
Yes, just a minute. Where is the order?
Yes, kindly see the order now. Page 31. More of it. Lord, you see the page
25, page 25. Starts from 27. Judgment starts from page 27.
The relevant findings of the honorable single judge, which your lordship on contesting, your lordship kindly mark. This is a matter also for your concern, of course, not at this stage, that how can a human rights commission exercise a jurisdiction in this?
No, Human Rights Commission did not exercise any jurisdiction.
He directed everybody.
Did not direct.
He did direct everybody.
Must have just forwarded those.
No, not forwarded only. Your lordship page 31. I'm not challenged that, but I lordship must come to notice because page 31, your lordship sees the human rights order.
Mr. Patil, just one moment. Annexure 7 is the order of this inquiry report. So all that it relates to is throwing of litter by your guests.
That's all.
That's
litter
all.
By guests. By litter by guests, my lord, in fact, I have stated prevented. I have litter by guests, they wanted a wall.
That is the inquiry report I saw.
Yes. And the wall, I made a wall. Now, yes, there could be some litters. I made a wall now, and the hotel is stopped by them. The hotel is stopped on different grounds, which are totally german to pollution. Pollution, my lord, is concerned with pollution. If I have pollution and I have stated before them in representation, and I said that I have not littered the ground, whatever litter, I have made a wall. I made a wall. Now, at a hotel, my lord, 48 rooms, lordship knows so many people working there. Start functioning because now they come up and appeal. They are implementing the High Court order and no authority.
All right, let us come to paragraph 11 of the judgment. What is wrong in it?
Sir. Right. Para 11, my lord.
Yes,
Yes,
what is
lord.
BPL?
Yes. If your lordship is page 41, para
What is
11.
BPL?
Yes, my lord. Further, such lands are Kasma lands and is renewed in BPL cases, means Balu cases, and then the same being renewed being made freehold. In the Stitiban permanent pata is given, which has not been done in the case of petitioner, even though he claimed to have purchased from Karmakar. Because I am from Karmakar, I have purchased. Who is the original who had purchased from him? As evident from RST, Deepak Karmakar sold property purchased by him the petitioner in 2008. By that time, he had neither had any leasehold right nor given any permanent right since the lease period expired 95. But the law is, in fact, that was not an issue. So no, the law is, my lord, this leases. I've got judgments of the High Court.
No, but whether this aspect was dealt with by the Pollution Control Board.
No, the Pollution Control Board has only relied and made it paraphrased and said that this has happened, and stop your construction.
All right. Come to this order.
Sir, I'll just explain to Lordship this. Sale deed is null and void. Thus, the petitioner has no right, title, and interest. Not the honorable single judge has come under allegation of responsibility sale deed. But what has happened, Lord, I'll tell you. I'll explain this aspect also, Lord. In a lease granted in Puri are Khasma leases. The Khasma leases, my lord, has a period. The period is, suppose he expires and the person applies. Who has applied? The person who was the owner, then it's Karmakar, that means from whom I have purchased, applied. When he applied, the appeal is pending. The High Court has stated in a judgment, which has been followed in series, it's well established, I've got a copy, judgment, that once the lease is granted, it is heritable and transferable. And I have a right to take it. The government has no right to refuse it unless it is for public interest. This is the judgment made in Kasmal in this. I've got a judgment. This is the area. So everybody has a right to take it. He has a right. The government has only right to refuse it if it is public interest. So I have my predecessor's interest had a right. He applied for lease. So whatever I purchased means whatever right he had, I have. If he had a right to get it, I have a right to get it. So that is my position. I have a right as much as he had because he sold it to by registered held it.
You had taken it from
the Karmakar, the person who had applied.
From him.
The respondent, he means the respondent number 3 first sold it to one Karmakar, third party. The Karmakar he himself sold it to Karmakar. Then after Karmakar Milord had the right, he applied for renewal of lease. At that stage, he applied for permission of a hotel, and the permission hotel, because of his incapacity, he sold it to me. I purchased by registered sale deed the rights of Karmakar and the title of Karmakar, the permission of Karmakar, which has I step into his shoes wherever he is. I am now, but the court said that since he had no right, my sale is void. Lord, this sale void means, Lord, I have given a judgment to your lordships that this sale void, your lordship says, at the your straightaway lordships go to, this is the judgment of the entire Kasmal, Lord. I have copied them, 2 copies, Lord. And only for littering. His land, his hotel is there. His hotel is there.
That you have not investigated whether he has.
No, I have not. I have not yet found out whether his right have been renewed or not. But first of all, he has no locus standi to initiate any proceedings. The only thing he can and should have or ought to have that whether I am littering, that infects his rights. If I am littering any waste or anything, of course he is affected. To that extent, he make a complaint, and to that extent, authorities can direct you, don't do it.
No, but now it is not the question of his right.
Now it's a question of
once the matter has come to the High Court.
Yes, sir.
The High Court could have or can examine so many
yes,
things,
examine other things also, but the examination is wrong because the right what the High Court said that the sale is void was first of all the High Court can only examine a matter which is under the lease of the High Court, in the sense, what was the lease of the High Court? That I am not littering, I am not wasting, and my pollution should not take any action. That was the only lease before the High Court. Supposing the High Court, Lord, in this external jurisdiction, goes beyond it. But it's also a wrong decision. To that extent, Lord, I have said that Lordship sees 2012, and your Lordship sees the 4th page, I don't know, page mark or not. That would be the 4th page, Lord. I didn't see the page mark. Rights. This is the principle applicable. Entire Puri is governed by that. And cut everything. But if you see the third paragraph, rights of a lessee in customer lands in no way different
Which
from
page?
those. Sir, page mark, I couldn't get it, sir.
Page,
Because I am
yes,
thinking of
2000, yes,
Yes,
I could get it.
yes, 104 is the side. If you
Based on
see.
Republic of India versus Praful Kumar Samal.
Yes, that one, my lord. Regarding the status of customer, the same is no more res integra in the decision of this court. Republic of India versus Samal, and in paragraph 4, right of a lessee in customer lands are no way different from those which are their own private land. Clause 15 of the lease deed confers the right of renewal of lessee, and as been pointed out earlier, the state cannot be denied to the lessor. Besides the lessee's out earlier, the state right cannot deny it beside the lessee's right in the customer land being heritable and transferable.
So why did you not bring this to the notice of the learned?
But that was never an issue. So I did not bring it to the notice of your lordship, right? Because what happened, my lord, I said and came before the court. What was
All
my
right,
plea?
just serve a copy on him.
Yes, sir. So one thing is that the
The only thing that there is
hotel has been stopped on the ground of Westmet.
We can expedite.
Yes, and lordship,
We
the
can
only thing that
expedite.
I'll give him copy tomorrow, lordship.
No, but he may also have.
So lordship, I have fixed the date after 2 weeks.
Yes.
So, but it's-
Mr. So and so has entered appearance on issue notice. You appear for whom?
No,
I am for respondent 3 and 4.
He is the complainant. He
I am
is
the complainant.
So let him also produce here his rights.
Thing
We
is that
have copies, na? We have soft copies to you.
copy has been there.
You are for whom?
I am
He is the pollution.
This is for state pollution control board.
So I thought you were for the municipality.
Closure is a consequence of the High Court order.
33B, your worship, of the Water Act lies to the NGT, as per the closure section under section 33.
I can explain to your lordship, once is by persons of High Court order, which authority in the world will examine the matter? It is the High Court's order. Under the High Court's orders are, if the High Court observations are not left out or interfered with by
The
your
order of the
lordship,
High Court before the NGT.
order, nobody is.
No, Mr.
Nobody-
You may be correct in your submission. You may be correct in your submission, but because of this observation made by the learned single judge, we may have to examine it. All right. So far other aspects are concerned.
Other aspect also.
That your lordship.
He was running the unit without consent.
That your lordship.
He was running the unit without consent of the board. Then your lordship, the closure direction has been given.
All right, so we are not doing anything. We are just issuing notices. All right. They are not passing any interim order for the
Your
question.
lordship here, these are deemed consent.
To accept notice on behalf of.
Respond number 2. Respond number 3 is the complainant. He has
Sorry,
appeared.
Three
He
and
has
four
served
are
copy.
associated.
State.
State, your lordship.
Respond
I'm
number
appearing
one.
for the state. One.
Considering the urgency of the matter as the consequence of the decision of the Pollution Control Board, which was under challenge before the learned single judge, is closure of the appellant's hotel, list this matter on 3 weeks.
Yes.
Within first 5 cases.
I have a small prayer to your lordships. But there are 2 aspects. One is the operation of the order be state, other is the opening of mine because of closure. The opening matter your lordships will consider after it. But there are certain observations will now, my lord, have a cascading effect. My application for renewal will be rejected on because
We will see every aspect.
Yes.
We will see.
On the next day, your lordship may hear and
We'll see.
Grateful, sir.
You just come ready with all the.
Grateful, sir.
Item 11.
May I please, Your Worship?
In this matter,
My lord.
senior administration has already appeared for the petition. Just serve me a copy, I can assist you.
I am giving a copy. I am giving a copy. I have given the copy. I'm only praying, my lord, the concurrent findings of the courts below, declaring the election of the present respondent as void for the office of servants has been offset by the Honorable Single Judge. Since my friend has appeared, I have given a copy. I humbly pray your lordship may fix a short date and hear the matter and dispose of. That much I am praying, my lord, humbly.
Yes, yes.
That much I am praying.
Mr. So accepts notice on behalf of behalf of
My lord, the original writ petition and now respondent number.
Only respondent.
contesting respondent. So stop. This matter on 4 weeks.
No, I am praying for a short date, my lord. I humbly, because now personal to the implement.
Just see the, listen to the order. 4 weeks. The first 5 cases.
Deeply
As
grateful.
the dispute pertains to election, the post of
Sarpanch
of a Gram Panchayat, which has been nullified.
No, it was nullified by both the courts below. Now, Honorable Single Judge has restored him.
All right.
Restored her. Nice. Deeply grateful.
Item number 12.
Yes.
May I please? Here, my lord, the matter relating to appointment of Anganwadi worker, my lord. Here, my lord, the advertisement is under Annex 1, it is Odia. And though I have filed, my lord, the English translated copy, there are some typographical error, my lord. My lord, I have corrected the same. Lordship, kindly.
The crucial document, the documents crucial for determination of the issues involved, the present writ appeal are in Odia language. So stop. Let the matter be placed before appropriate bench. Instead of directing for supplying English translation of the said documents, it is considered desirable to in the court's opinion, the matter should be placed before an appropriate bench after obtaining necessary orders from the Chief Justice. Place the matter accordingly.
May
before appropriate bench.
May I draw your lordship kind attention, my lord. Lordship, can see the order impugned here, my lord. The honorable
Mr. Counsel, we are just saying that this appeal will be placed before an appropriate bench, because I'll have to depend on.
I am obliged, my lord. Because what happened, my lord, this week only I pray, my lord, because honorable single judge has directed, my lord, the appointment of the appellant is set aside forthwith, and the respondent number 5 will give an appointment in place of her. That is there, your lordship kindly to see.
So the matter will be assigned to a learned division bench today.
Obliged.
Item number 13.
May I please your lordships. I may be permitted to VC your lordships. Item 13, I received the counter affidavit. Lord, I placed short the time, my lord, to file reasoned affidavit, your lordship.
The tenders have been cancelled, Your Lordship. And
The tender notice has been cancelled.
yes, Your Lordship, with the approval of the government, Your Lordship.
Then
26.
what remains?
The subsequent tender, my lord, I have, my lord, they has not disclosed, my lord, what they.
We have disclosed, Your Lordship. Fresh
The
tender has been invited. It has
Which-
been cancelled with the approval of the government, Your Lordship, by the tender committee.
Tender has been cancelled. Then
My
what remains?
lord, here is my lord, my case with your lordship, there is a cancellation and retender was challenge because I have the condition provides if the tender, my lord, the tender will be selected through transparent lottery if bidder or quoted equal rate. Here, my lord, number of bidder quoted equal rate and lottery I have selected. Thereafter, they cancel retender was challenge, my lord. If the retender was cancelled, I have no objection, my lord. They have so they
Are
have,
you saying the subsequent tender has been challenged or the original?
The original tender.
Original, he's challenging that.
The original tender, Your Lordship, that has been cancelled
That he is,
by the approval of the government, Your
that
Lordship.
he's challenging.
Yes, Your Lordship.
And
He's
the-
saying that I was not assigned any reasons. That has been discussed in the tender committee, Your Lordship.
All it is stated by learned counsel appearing on behalf of the petitioner that needs time to consider the counter affidavit filed on behalf of the opposite parties and file
rejoinder affidavit.
and file a rejoinder affidavit. Stop. The counter affidavit is not there on record. Is it there?
When did you file the counter?
Counter on 3rd of September, Your
He
Lordship.
filed, right?
Stated. I'll just give a report. London. AGA has submitted that the said counter affidavit was e-filed on 3/9/2024. So, let the Registrar General submit a report, a detailed report dealing with the circumstance in which the said counter affidavit has not been brought on record. First off, he'll be required to suggest the remedial measures to be taken on the administrative side of the High Court to ensure that the pleadings which are e-filed or physically filed in different cases are promptly tagged with the concerned brief. Publish this matter on 4 weeks. 4 weeks. What about the work?
Let the short date maybe fix it.
Yes, 1 week.
10.
1 week.
Yes. Oblige.
Item 14.
The petitioner in this writ application challenges the notification whereby my lords NOC is being granted to the college, not nursing college, my lords, every year, my lords. It should be for the entire course. My lords,
Why?
My lords, I'm placing before your lordships. The BSc nursing degree, my lords, is for a period of 4 years, my lords. There are 8 semesters. That is in the Gazette, my lords. They have described the BSc nursing services. I mean, course. Now, my lords, what happens?
Though we prima facie agree with what you are submitting, but we still want to know the reason why.
My lords, once NOC is granted, there is a particular manner in which the NOC can be revoked. Suppose I deviate, because every year they have inspection for recognition as well as
No, but
affiliation.
what is the procedure prescribed under the
My lord, they
regulation?
have to give me a show cause and then revoke my NOC.
No, is there any prohibition or is there any requirement under the regulations that the NOC is to be granted for the
For
without
1
any
year.
period for?
There is no such prohibition, no guideline, no regulation. They say it is for a period of 4 years and NOC is to be granted, and we have to take NOC from the board, and which we have already taken. Now, my lords, what is happening every year? Our course is starting in September because of this grant of NOC, my lords. It's going from
Yes,
April
going
to
for the
September.
DMT.
DMT and government.
You some copy on you.
My lords, we'll
No
serve.
copy has given.
Copy
DMT.
is being given to DMT.
No.
We'll serve. We'll serve.
All right. Issue notice.
Obliged.
So and so accepts notice on behalf of let exhaustive counter affidavits be filed. Let the DMET justify the reason as to why the no objection certificate.
Yes, no.
No objection
NOC,
certificate.
no objection, sir.
Bracketed NOC for running a nursing institution. A nursing institute is granted for period of 1 year only and not for the course.
Entire.
Not for the entire course.
Course.
We are a nursing institute. The petitioner is a nursing institute.
No, it is a organization.
Course.
This is a federation.
So the NOC is granted in respect of running of a course, not
Yes, ma'am. Yes,
like for establishment of the institute or running the institute.
For running the institution, we have to give an.
A course. All right. This is matter on 4 weeks.
Obliged.
Item 15.
May it please, Your Worship. This is the second round of litigation. The petitioner is constrained to invoke Your Lordship jurisdiction. Lordship will kindly turn to page 147, annexure 30.
Just. Yes.
Lord, page 147, annexure 36 is the impugned order. This is a case of lapsing, my lord, under the minor mineral rules, my lord, 2016. Lord,
you have challenged this order
at annexure 36, page 147.
But you have remedy or filing revision?
My lord, a revision provision will not be there, my lord, because this is not a major mineral, my lord. Therefore, I cannot approach the central government, my lord. I have to come, either I have to go back to that authority or I have to come before Your Lordship. And why I am before Your Lordship is, my lord, annexure 36, annexure 36, my lord, the impugned order is an outcome pursuant to Your Lordship's direction, my lord. Identical reasons, my lord, denial of non-consideration of my show cause, non-consideration of a judgment of this honorable court led me to come in the first round of litigation. I have annexed that order. Your Lordship was pleased to give 5 broad parameters and sent me back to that authority. Now, the authority, instead of, my lord, revisiting his order, has paraphrased and come back with the same reasoning, saying that no cause is made out for that period wherein I had closed my mind. No cause is made out to condone that period. Hence, it is treated as lapse. I'll take Your Lordship, my lord, to the first round of litigation.
No, but where is the lapsing provision?
My lord, lapsing provision is 26(9) of the Mineral Concession Rules 2016.
Mining.
Lordship sees the Mineral Concession Rules 2016.
Mineral concession.
This will be the Orissa minor mineral concession rules, 2016. It will be in the local
This
laws
is
book.
minor mineral.
Minor mineral. This is granite. So it's called described
Orissa.
Orissa minor mineral concession rules.
Odisha, there is Odisha minor mineral.
Minor. 2016. Lordship
Yes.
takes rule 26, sub rule 9.
Yes.
I'm placing 26(9), my lord.
Yes.
If the lessee does not work upon the lease for a continuous period of 2 years, the lease shall be liable to be cancelled unless prior permission has been granted by the competent authority for stoppage on reasonable grounds. Provided that the competent authority may, on an application made by the lessee before it is cancelled, and on being satisfied that it will not be possible for the lessee to undertake mining operations or to continue such operations for reasons beyond his control, make an order within a period of 3 months from the date of receiving such application and subject to such conditions as may be specified to the effect that such lease shall not be cancelled. Provided further that the state government may, on an application made by the lessee within a period of 6 months from the date of its cancellation and on being
So you
satisfied.
had made an application before it lapsed.
Lord, Lordship sees the impugned order, which is the order, the impugned order. I could not have made an application, my lord, because the authority which issued me the stop mining order.
No. The order is not required. Any order is not required for lapsing.
My lord.
The lapse takes place by operation of law.
I am obliged, my lord.
All
Yes.
right. So
Yes.
you have to make an application before that period expires.
My lord.
So is this your case that before 2 years that period was going to expire, you made an application as required under sub rule 9?
My lord, my case is the authority who is to grant me the permission to close the mine is the authority who stopped my mine, and that is at page 53. The authority, namely the mining officer who is competent for granite, my lord, is the authority who stopped my mining operation.
Yes.
Lord, at page 53, the clear copy is at page 54. My lord. There were 2 reasons for which I had to halt mining, my lord.
So when was the period going to expire?
My lord, Lordship takes 54 for a moment.
Just a minute. So when was that period going to expire of 2 years?
My lord, the 2 years period was to, my lord, if I may point out, my lord, 16/1/2012. I was directed to stop mining. So the period would be, my lord,
Forget period. Let us come to the rule.
my lord.
If he does not work upon lease for a continuous period of 2 years. So when did it start? When you stopped working for any reason?
16/1/2012.
16/1/2012. Mining activities were stopped.
My lord, by the mining officer.
Where is the order?
Page 54, my lord.
Yes. Just a annexure.
Annexure number 3, my lord, the typed copy is at page 54. 53 is the original, 54 is the typed copy.
Yes.
May I place 54, my lord?
Yes.
My lord, this is issued by the government of Orissa, Office of the Mining Officer, Ganjam Circle, Barampur. Subject is extension of minor mineral mines having leasehold area of less than 5 hectares, obtaining consent under Section 25 of the Water Act 1974 and
Yes.
Lordship has it, my lord?
Please,
My lord. Sir, in inviting a reference to the letters on the above subject, I am to say that you are required to obtain environment clearance in respect of your mining lease for minor mineral decorative stone as per EIA 2006 issued by the ministry dated 14/9/2006. Mines having less than 5 hectares of leasehold land, leasehold area, Lordship turns the page.
Yes.
My lord, it's a typo error, are exempted from obtaining environment clearance. As the matter has been decided by the board in its 100th meeting held on 23/10.
So this was issued on 12.
In 2012.
So what did you do thereafter?
My lord, I immediately, my lord, applied for my environment clearance. I stopped the mining operation and applied for environment clearance.
When?
I applied for the environment clearance, my lord. That would be on your lordship's record, my lord, at page 79, and it's pending till today.
When?
Page, I'll come to that. Lord, February 2, 2017 is the acceptance letter.
To
February 2nd, 2017.
Immediately after 2012.
My lord, the application was filed. They have finally accepted it on.
So 5 years, according to you, is immediately.
My lord, there is a long story behind it, wherein, my lord, the application was returned due to the change of law, etc. I'm not bothering your lordships with that.
Oh, you should bother us.
I'll place that.
Whatever the facts are, but the question is that since 2012 you are not doing mining activities for any reason. You applied for environment clearance, that is pending. But the fact remains that for 2 years, 15/1/2014, this rule 626(9) came into operation. So you should have applied. That this is the reason why you are not carrying out mining activities.
My lordship will see, my lord, what the show cause they issued to me and why I came before.
Why show cause? It's a simple case.
My lord, the law changed between 2012 and 2016, my lord. And this reason for applying environment clearance came because of a Supreme Court direction. Earlier, for minor minerals, it was not required.
Again, we are putting the same question. If because of an order passed by the mining authority on 26/1/2012, you could not carry on your mining activities, then before that period, you could have applied that this is the reason why I am not carrying out the mining activities.
Milord, what happened was, Milord, while I had applied and that application was pending, they issued me 2 show cause notices. I'll place the show cause and your lordship's direction pursuant to the show cause. That will clarify the issue. Milord. Kindly take the first, Milord, the first impugned order, the first order which was impugned on the first round of litigation, Milord. That is at page 128. That is the first impugned order wherein I came before your lordships. And all this has been considered by your lordship. Kindly see the first impugned order. It is dated on the right, my lord, at 9/8/2021. May I place that order?
Yes.
My lord, whereas mining lease for decorative stone was originally granted in favor of Srimati so-and-so for a period of such and such under the Orissa Minor Mineral Concession Rules 1990, which expired on 24/10/2010, lessee applied for renewal of mining lease on 30/6/2010 before 3 months of expiry of the lease. After the expiry of the lease, the lessee continued mining operation under deemed extension as per Rule 57 of the 2004 rules. Subsequently, my mining lease has been extended for 30 years. The mining operation was stopped by the mining officer Barampur on 16/1/2012 due to want of environment clearance. Whereas mineral was extracted for the lease area during the period of 2010 to 2012 without valid environment clearance and pollution clearance, for which the collector Parlakamudi has filed case number 2CC before SDJM Parlakamudi against the lessee for the said offence under section 15 of the EP Act, which is sub judice. A demand notice was issued by the mining officer Ganjam under 21.5 of the MMDR, read with Rule 51.4 of the OMMC rules for the unlawful production of minerals violating EP Act 86 for the period 2010 to 2012. Imposed penalty is still due with the lessee. Lordship turns over the page.
So before 2016, what were the provisions?
Lord, before 2016, the 2004 Act was in vogue, Lord, and prior to 2016, no environment clearance was required.
Sir, we have put this question. You are relying on 2016 rules. 2016 rules were not applicable when 26/1/2012 order was passed.
I'm obliged.
So by operation of, you cannot rely on this 26 to 26 9 of the concession rules, which are of 2016. So this, therefore we want to know what was the provision before 2016.
My lord, the relevant rule, my lord, prior to 2016 is the 2004 Orissa minor mineral concession rules.
Where is that?
Lordship takes the Orissa minor mineral concession rule.
Where is the provision?
I'm just taking your lordship to the provision. Lordship will see, my lord, Rule 25.
Yes.
Rule 25, Sub-Rule 5, my lord.
Yes.
If the lessee does not work upon the lease for a continuous period of 2 years, the lease shall be liable to be cancelled unless prior permission has been granted for stoppage by the competent authority.
So this will apply in your case. This will apply in your case, not 26/9.
Very well. Very well. Well, considering this.
Very well, you are complimenting us, you are patting our back.
Not at all, Milord.
Well done.
Not at all, Milord. Not at all. Milord, why I cited 2016 rules is the second show cause is under the 2016 rules. The first show cause is under the 2004 rules. That's why I was citing the 2016 rules. Milord. I'm obliged, Milord. Kindly see, Milord. The competent authority can condone it only on reasonable grounds. This honorable court considered this aspect, Milord.
Yes.
In a writ petition, wherein I came before your lordship, Milord. Lordship will get that at page 132. I'm sorry, Lordship will get that at page number 143. That is your Lordship's order.
Yes.
Annexure 35, Milord, at 144. Lordship has that, Milord?
Yes.
Paragraph 3. Mr. Das, learned counsel for the petitioner, has contended that the present matter is fully covered by the judgment of this honorable court in SL Mining.
144.
Page 144, paragraph number 3.
This is in WPC 134150.
No, my lord, it's in WPC 34150 of 2021.
That one.
That's at page 143.
Which annexure?
35.
35 is WPC 34150.
150. That is the order I'm placing.
Yes.
Milord.
Annexure?
Page 144, Milord.
Yes. They are just coming back.
Milord. Union of India. In which one of us, Dr. Justice B.R. Sarangi, was a member, and therefore the impugned order passed by the authority lapsing the mining lease under 26(9) of the OMMC rules cannot be sustained. So far as the compliance of the principles of natural justice is concerned, it is fairly stated that 2 show cause notices were issued against the petitioner, which were replied by the petitioner. However, the same was not considered in proper perspective when the impugned order was passed, which has been challenged by the petitioner in the present writ petition. Thereby, it is stated that in similar circumstances, the authorities have automatically withdrawn the lapsing order because of the compliance of the conditions stipulated therein. It is submitted that since the petitioner is in the same footing, similar benefit has to be extended to the petitioner by keeping in view the judgment of this honorable court in SL Mining and Industries, as well as orders passed in other similar related mining cases which have been placed on record under Annexure 35 series to the rejoinder filed by the petitioner. I kindly skip over and come to paragraph number 5 at page 145. That is the finding of your lordships. Having heard learned counsel of the party for the parties, and on perusal of the materials available on record, as held and since in principle has been decided by this honorable court in SL Mining Industries Supra, so far as the lapsing part is concerned in that case, the authority shall consider the case of the petitioner in light of SL Mining and extend the benefit thereof to the petitioner. So far as compliance of natural justice is concerned, as has already been admitted by the petitioner that they have filed the show cause, this question no more remains to be decided by this court at this stage. Rather, the OP number 1 should take into consideration that similarly situated mining leases, lessees who have been granted permission after complying the provisions, and that be so, the same shall also be taken note of by the authority. 146, the next page.
So SL Mining, I think only point was that should be given a chance of hearing.
Chance, and the authority has to satisfy itself as to whether I have a reasonable cause as to why I stopped
What is
the
meant
mining.
by hearing?
Milord. And kindly see 146, your lordship notices.
Just a minute, whether in SL Mining, the applications were filed before the lapsing or after the lapsing, that is the question.
Milord, no application was filed there either. The authority proceeded for lapsing.
The decision of this court.
Milord.
Let us see.
140.
No, where is that decision?
I have annexed it, Milord, at Annexure 34, page 132.
Yes.
And this was a case of major minerals.
What is the provision in measurement? Is there any difference?
Automatic lapsing not working for 2 years. Very identical provision.
Let us. Yes, where is the...
Milord, the relevant part, Milord, starts at page 140. Paragraph 12. Milord.
Yeah.
The paragraph 12, Milord, at 140. The apex court has considered the question of automatic lapsing at length and has concluded there cannot be a deeming provision for automatic lapsing of lease, as the leaseholder could have valid reasons for discontinuance, which could be because of an order passed by an authority or other legal compulsions. Therefore, Milord, the valid reasons is an order by an authority or other reasons, and I squarely fall under this, and that is just, Milord. In the facts of the present case, an order of automatic lapsing has been passed on 28/2015, much after the expiry of the period of 2 years of discontinuance of the mining lease, and even after an application dated such and such was pending before the state government, explaining the reasons for discontinuance of mining for the aforesaid period of 2 years with the prayer of revival of the lease. The date which has been taken into consideration for the mining lease as non-operation is 22/11/2012. The same was because of the reason that the DFO had passed an order of suspension of mining operation.
Come to paragraph 11.
Paragraph 11.
That is the law laid down by the Supreme Court.
Milord.
Read it.
Milord.
Read it
Based
loudly.
on the interpretation placed by us on section 4 capital A subsection 4 of the MMDR and rule 28 of the mineral concession rules, we can draw the following conclusions. Firstly, unless an order is passed by the state government declaring that a mining lease has lapsed, the mining lease would be deemed to be subsisting up to the date of expiry of the lease period provided by the lease document. Secondly, in situation where an application has been filed by a leaseholder when he is not in a position to carry on the mining operation for a continuous period of 2 years, the lease period will not be deemed to have lapsed till an order is passed by the state government on such application. Where no order has been passed, the lessee shall be deemed to have extended beyond the original lease period for a further period of 2 years. Thirdly, a leaseholder having suffered a lapse is disentitled to any benefit of the amended MMDR because of the express exclusion contemplated under 8A9 of the amended MMDR.
Yes.
Therefore, my lord, the valid reason which was available to me was the letter dated 16/1/2012. And I stated that in my show cause notice. And in the present impugned order, my lord, without considering that very aspect, the authority repeats the impugned order which was dealt with in by your lordship in WPC 34150.
Yes.
9/8/2021 was the first impugned order. I came before your lordship. Lordships remitted me back to the concerned authorities, telling him that please deal with the show cause notices, wherein I have stated very clearly that the reason why I have stopped operation is order dated 16/1/2012 and a criminal case which was instituted for the death of certain goats.
Yes.
And that criminal case has also ended with me being exonerated.
And what about clearance, environment clearance?
Environment clearance, my lord, because the lapsing order has now been passed, my lord, first in 2021 and now, my lord, repeated the same order. The authority OP number 6 is not proceeding with my application. The authority says first you get your lease revived, then only a question of environment clearance would be considered. And my lord, the glaring aspect which comes before my lord, is in the impugned order which starts, my lord, at 143. The show cause notices are mentioned, the replies are not considered. I'll take your lordship to the first ground of violation of natural justice. Second, my second ground was I have an accentuating circumstance, which is the order of the mining officer 16/1/2012. It is the same officer who will grant me the permission to close. So there was no purpose served in going back to him because he said halt mining till you get your EC clear. My EC consideration is pending. All paraphernalia vis-a-vis from me is complete. Third, my lord, similar mining leases, which were identically circumstances, I have annexed that. If your lordship pleases, I'll place that, of decorative stone. Identical situation. Condoned, lapsing, withdrawn, my lord. I fall squarely under that. And most important.
Where is that statement?
My lord, that statement, my lord, is there on your lordship's record. It starts, my lord. I have annexed the entire set, my lord. It starts on your lordship's record, my lord, at page 149. I'm sorry, my lord. It starts in your lordship's record at page 193. I'll just give two brief examples, my lord, which will make it absolutely clear. Relevant, my lord. Lordship may take at just take your lordship, my lord, to decorative stones which is dealt with, my lord. Kindly take 150.
150 or what?
Of your lordship's brief, my lord. It is part of
RTI.
RTI. Annexure 37 series, that's the RTI I obtained. This relates, lordship sees the heading, my lord. Hearing on lapsing of mining lease of decorative stone on 78 acres or 31 hectares in village Bhagwanpur of Ganjam district in favor of Amar Jyoti Granites. Identical case, my lord. Penalty imposed, EC pending.
Let us see.
My lord. Whereas the mining lease for decorative stone over an area of 31 hectares in village Bhagwanpur of Ganjam district was executed in favor of Amar Jyoti Granites on 17/1/96 and registered on 18/1/96 for a period of 10 years.
So come to second paragraph.
Second paragraph. Whereas application for renewal of mining lease was submitted by the applicant company on 6/10/2005 after the due date. As per the deemed provision of Rule 57 of the OMC Rules 2004, applicant company operated the mines till
before the due date. It's not after the due date.
My renewal was also before the due date. No dispute on that. My renewal application for extension of the lease is admittedly before the due date. No dispute on that. The only place where I have not submitted an application.
No, your application was your application before 2014.
My application for.
When did you file your application?
For Milord, for informing the authority that I am stopping the mining lease, Milord, I will state, my lord, I have not filed any application because it was the very same authority who's competent to grant me the permission who stopped my mining operation.
Sir, therefore, you could have taken this plea before the authority that this is the reason why I have not been able to continue the mining lease and I cannot continue with the mining lease for 2 years.
Milord.
So this is, see, you are equating your case with this.
Milord, this, what is mentioned in paragraph 2 is the renewal application, Milord, for renewal of his lease. And my renewal was within time, no dispute on that.
The renewal was in due time.
My renewal is within due time and that is noticed in the impugned order. That I have filed my renewal application, my mining lease is till 2030. No dispute on
So
that.
when was the renewal granted?
I'll place.
Date.
But this is not a case of lapsing then.
Well, this is a case of lapsing because my renewal was granted and
No, your case is a case of lapsing, but with the, you are referring to this, whether it's a case of lapsing.
Lapsing, Milord. Lapsing, Lordship will find at 153.
Where is that?
Kindly take the last paragraph, 153.
Yes.
In view of the above, the state government, after taking into consideration all material facts and information available on record, upon hearing, have been pleased to declare the mining lease for decorative stone on 31 hectares in village Bhagwanpur of Ganjam district in favor of Amarjyoti granites as not lapsed under 26(9) of the OMC rules. Also, as the lessee has established cutting and polishing and processing unit within the original lease period, the mining lease is eligible for extension under 8A of the OMMC rules. Hence, the lease period be extended for 30 years from 17/1/1996.
According to you, in this case, when was that period going to lapse? Period of 2 years. Because that period of 2 years will start from the date when 2004 rules came into operation. Alright. So whether before 2 years the application was filed or after 2 years the application was filed, that is the crucial thing.
What I'm endeavoring.
See, no decision can be contrary to law.
Very well.
All right. And if any decision has been taken contrary to law, the court will declare those decisions illegal.
Lordship,
even if that has been done in the state of Odisha.
Lordship, pleases me. Lord, what I humbly endeavor to place, my lord, is the reasonable cause, which was the letter dated 16/1/2012.
See, Mr. Counsel, by operation of the provision, mining lease lapses if the mining activities do not continue for a period of 2 years and no application is filed in the meanwhile.
Very well.
So if your case falls in that category, you don't have any case, one. And two, if the government has granted in some of the cases, all those the decisions may have to be declared illegal.
Mr. Das,
Milord.
this decision you are referring to, is it under OMC rules 2004 or 2016?
Milord, this would be under the 2016 rules, Milord, because the order is dated 5/8/21, Milord.
Yes. File your affidavit, we will see. But we are making it clear. We are of the prima facie view, based on the reading of this 2004 rules and 2016 rules also, that the lapsing is automatic by operation of those provisions if no application is made.
Yes, Your
If any application is made, then if no decision is taken on that application, it shall continue up to the period of lease.
So, Lordship, that SL Mining and Industries, Your Lordship, they had applied, explaining the reasons why they have not mined for 2 years.
No, madam.
Yes, Your Lordship,
They had
12.
also not applied. They, after the lapsing, they had
Lordship
applied for
was,
revival.
Lordship was
Lordship,
part
but
of
Lordship doesn't have that phenomenal memory to remember. I went through the judgment and then I'm
So,
telling you.
para 12, Your Lordship, where it has been stated that in the facts and present case, an order of automatic lapsing has been passed on 28/2015, March after expiry of the period of 2 years of discontinuance of mining lease, which was on 22/11/2014. And even after an application dated 6/5/2015
difference.
was pending.
For that is for revival, not for
Yes.
explaining the reasons.
explaining the here, but it has said explain the
You have to
reasons for
you have-
discontinuance, but not on that provision, Your Lordship. So
And my lord,
All right, file your affidavit.
I'll file.
4 weeks time is allowed for the estate to file counter affidavit. This case on 4 weeks.
Item number 16.
Lord, notice on the interim, Lord, Your Lordship.
No.
I have filed an application for interim.
That,
Well, deeply obliged.
Yeah, please, Your Lordship.
These two?
Serve extra copies, my lord, on the state.
is that required?
Your Lordship, no. We
Deeply.
had it.
Yes.
You require extra copies or you'll send by your email or whatever?
Email, Your Lordship. We are downloading it from the LMS.
May I please, Your Lord? The petitioner here was awarded with a contract for running the taxi services in the Jharsuguda airport. Your Lordship. Jharsuguda airport. The award is at running page 102.
Yes.
The said contract was valid for 3 years.
Yes.
May I take Your Lordship to the award, 20th April 2022 at page 102. Here, Your Lordship, he was also provided with a designated area for having his business inside the airport terminal. And he was paying a price for that also. That is the reference may please be made, write e-tender so and so to allot space for general maxi car rental services.
You are challenging the first tender.
Yes, Your Lordship, with all these irregularities of the opposite party, for removing him, first he was removed from the designated area, even though he's paying a price for it, Your Lordship. He was
No, but
removed.
that action may be illegal, but what right do you have
Now,
to continue?
now, without any novation of the contract or anything, they have come up with a fresh tender. I have been writing to them continuously.
No, no, where is your contract?
The contract is at Annex 4, Your Lordship.
For how?
It's for 3 years.
3 years expired when?
No, it has not expired. It is still till 2025. The contract was executed in 2022, valid
Yes.
for, may I read out that portion, Your Lordship?
Yes.
Page 108. The last para. Now therefore this indenture witnesses that the licensee for the said facility shall be valid for the period of 3 years, and then unless terminated earlier on account of the following. And it commenced from 2022.
By giving 30 days notice without assigning any
Yes, Your
reason.
Lordship.
So here
That
not,
notice has also not been given, nothing. But here, first and foremost, my grievance is, even though I'm paying the price for that space which was allotted, and the map also was appended to my agreement, a designated place, I was removed. My business was hampered.
where is that removal?
Your Lordship, that is at page 1. Police FIR was also given, page 145, Your Lordship. Yes, sir, most respectfully, I beg to state that I, Biplab Kumar Biswal, Director of DXP, so and so, you, that forcefully you guys violate the agreement terms and conditions.
No, these are your letters. Where are their letters removing
Nothing,
you?
no orders were passed to that effect. I have been continuously writing to them. Nothing. There has been also.
That means while you are continuing, that tender has been floated. You are still inside.
Yes.
Or you
No,
might
I have
have
been
moved
removed. I have come
So
out.
how were you removed?
No, from my designated place, I was
How were you removed?
by no order. I was just asked that you shift, otherwise we'll
So
cancel.
how were you asked?
When?
Verbal.
When that happened?
That is on February 6th, 24, page 145, Your Lordship. I've
February
given them
6th.
series of mails. Letters.
February 6th, and when did you file the writ petition?
I filed the writ petition 24.
Huh?
24. This July 24.
July 24th.
Yes,
So
Your Lordship.
after 5 months of
No, again, there are also repeated emails regarding
mails is
the letters to them. One is May 25th. I have written the same thing.
Might have written the same thing, whether that is factually correct or not will have to be seen. File your affidavit, you will see.
Lordship, notice has to go. Your Lordship.
Notice,
Yes, Your Lordship.
Issue
Airport
notice.
authority.
4 weeks, 1 week, 6 weeks. Yes.
Item 17.
May
May please. May I please? It's permitted to place this matter before the Lordship. On behalf of the petitioner. Lord,
Do you need permission, Mr. Monty?
Well, because the appearance memo is not there, it is being filed now. That is why.
Yes.
Some decorum in the court should be maintained. Lord, under Annexure 1,
Yes.
National Highway Authority awarded a work to me to be completed within a period of 2 years, so far as rehabilitation and upgradation of 4 to 8 lanes is concerned in Chandikhol Paradip National Highway. The period of completion was stated to be 2 years. For the purpose, I required for the upgradation and construction of the roads, I require chips, black chips from the Blackstone quarry. So I applied to the concerned Tahsildar under Rule 36. Rule 36 is that you have to, instead of auction, you can apply if it is for a public purpose, to give me a Blackstone quarry. The Tahsildar Dharmshala gave a list. Out of that, he allotted me query number Azar 6. Then I told them that inspected the query and found no stone is available. I told that instead of 6, you give me 7. They agreed. Then after getting that, and deposited the required amount as royalty, and thereafter I have to do the entire process of giving a minor plan, getting environmental clearance, and approaching the state authorities, and ultimately, by page 33, I was granted state environmental clearance for the stone quarry, page 33, your lordships kindly see. By the state environmental impact assessment authorities. Then unfortunately for me, by this time I got it, the election was declared, so permission for quarrying was not issued till the election was over and the code of conduct was taken. Sorry, my lord, as issued query permit, but the blasting permission was not given, my lord. That is on record, my lord, I will place it. Then, my lord, after the state environmental impact assessment authority has given the clearance and blasting permission was given, my lord, then ultimately the permit was granted in respect of query number 7 on page 66, my lord. 66. May I draw your lordship's kind attention to page 66?
Yes.
As your lordship.
Yes. Which page?
Page 66, annexure 14 series. Has your lordship got?
Yes. Yes.
Then, my lord, your lordship sees page 66, the conditions, my lord, the permit shall be valid for 3 months from 10/7/2024 to 9/10/2024. Has your lordship got it?
Yes.
Then while I was operating this, lifting the, getting the materials from the quarry, my lord, by permit, my lord. Then all on a sudden, they stopped this under the impugned order, that is not page 78.
What is the date?
What
What
that
is the
is
date of?
13/8/2024. 13/8/2024. Page 78, Annexure 18. Whether I am in serial number 4, Anjira PSQ 7. Halting mining activities. Madam, sir, as per the letters of BFO Kotak Forest Division Kotak, you are hereby directed to halt, stop any kind of mining activity in your respective quarries until further communication at this end. So the work has now come to standstill. So I presume that BFO, there must be some environmental issue, not forest issues. But may I draw your lordship's kind attention to page 34, my lord. Before, my submission is before, my lord, grant of the environment clearance, my lord, everybody was heard. Reports were called from everybody, forest department, mining department, irrigation, everything. And after they cleared it, the clearance was given, my lord. Your lordship, page 34, your lordship, clause 3, my lord. The proposed quarry is not coming within the boundary of wildlife sanctuary, national park area, etc. The leased area is not coming under DLC list or oblique any type of forest land as certified by the mining officer. By letter dated such as the proposed lease area is not coming under the DLC list. So if it is not coming under the forest list,
No, it is not coming under that.
And the record is, my lord, I will say that, my lord, Tahsildar.
It is not in the within the boundary of wildlife sanctuary, national park.
This next one, 4, the lease area is not coming under the DLC list. That is district level committee, my lord, where they have identified, and according to the apex court decision, my lord, that even if the forest is not there, but where it is when district committee has concluded that it is a forest land, it will be deemed to be a forest land. Oblique any type of forest land as certified by the mining officer. Then, my lord, your lordship will kindly see the record of rights.
No, but what is the final?
The final, my lord, it has
opinion
come to a standstill, my lord.
No, what is the final opinion of this state environment impact?
They granted the clearance.
Huh? Where is that?
My lord, that is the certificate, no? That is page 33, my lord.
No, 33.
Your lordship sees the heading of the page 33.
Yes.
As your lordship, certificate of clearance, you know. Environment oblique environmental clearance for stone quarry. Then we learn at page 35/7, we learn. Plus 7, we learn. Has your lordship got it?
So where is the clearance given?
My lord, class 7, page 35.
34. No, 35.
Page 35.
Yes.
Environment clearance is granted under the provisions of Environment Impact Authority notification number such and such, dated 14 September 2006.
Yes.
So, my lord, now I am in a crossroad, my lord. the public work has been completely stopped. I have already invested more than 20-25 crores of rupees, my lord. The project is near about costing is 70 crores, my lord, and it has to be completed within 2025, my lord. And apparently I was not given any opportunity before asking me to stop operation of the quarries, my lord. While the mining permit was subsisting till 9/10.
Yes, state.
I have to take instructions.
You file affidavit by Monday.
I have paid the entire royalty to the tune of my allocation, my lord.
But your permit was valid till when?
Till 9/10. I have shown to your lordship's lord, page 66.
And where is the letter of DFO Cuttack?
But that is not there. That has not been given to me.
All right. Please seek instructions
Yes, Your Lordship.
and tell us tomorrow whether the counter affidavit can be filed by Monday or not. If you cannot file the counter affidavit by Monday, then we will have to stay. All right.
Yes.
This is third learned senior counsel appearing on behalf of the petitioner and learned AGA representing the state opposite parties. Stop. The petitioner has put to challenge communication dated 13/8/2024 issued by mining officer bracketed IC Jajpur district, whereby the petitioner has been directed to halt/stop any kind of mining activity in respect of the quarry, namely Anjira BSQ 7,
Blackstone
comma,
Quarry.
until further communication. So stop. He has submitted that the requisite permit for quarrying was granted on 10/7/2024.
That has been extended.
To 9/10/24. Valid for 3 months. They grant it at a time for
3 months.
3 months only.
Up to 10/10/2024. 9/10/2024, comma, in under Rule 37, Rule 36, Rule 34,
Comma, under Rule 35(1).
under Rule 35, yes.
Comma.
Just 1 minute, let me check up, let me.
So page 66, that is written on top.
Rule 35(1).
Rule 35(1) of the Minor Mineral
Concession rule.
Odisha Minor Mineral Concession Rules 2016. So he has argued that this said communication just refers to communication of the DFO, comma, Cuttack Division. Two communications of the DFO, and both are communications of the DFO dated 2/8/2024 and 12/8/2024, comma, without assigning any specific reason why the said why the said action was taken. Said action has been taken. Stop. He has drawn our attention to clause 7 of Which annexure is this EC?
State impact assessment. That
Clause.
is page 33. my lord.
7 of annexure
Type series.
4. Annexure 5.
series.
Annexure 5 series to submit that environmental clearance was granted in favor of the petitioner in respect of the stone quarry in question. So stop. Next, list this matter tomorrow within first 5 cases. So stop. First 5 cases, comma, so as to enable an AGA to seek instructions to the limited effect as to whether a counter affidavit can be filed by next Monday or not. So stop. We make it clear that if the opposite parties express inability to file counter affidavit by Monday next, comma, Tuesday next, the court will consider passing appropriate interim orders.
I was also thinking that I will pray that it may be placed next week at least, and at the earliest. Before that, your lordship has passed that.
Item number 18.
May it please, Millets. Millets, I've been allotted a sand quarry at Lungei in Lathikata Tahsil, Millets. I faced certain problems, Millets, in fact, for which I could not carry out the mining activity. And therefore, Millets, I have made certain representations. These representations are pending despite giving reminders. If your lordship sees annexure 8,
Representation.
yes, that's my representation.
No, let us consider your right.
10/6/2024. That's what really happened. If your lordship wants, I'll give the entire background, Millets. Here, if your lordship comes to page 13, is the quarry lease that is granted in my favor.
Yes.
This quarry lease was granted by way of a valid tender, Millets. Then, Millets, if your lordship sees the location, which your lordship will find at page 19.
Yes.
It is under at village Lungei, Tahsil Lathikata, district Sundargarh. Now, Millets, this was executed on 3rd of December 2019. Now, as we were just starting to progress with this work, COVID intervened, Millets, I couldn't carry out the work. Thereafter, Millets, subsequently, if your lordship will come to page 34, Millets, the State Environment Impact Assessment Authority, Millets.
Yes.
That also considers my request to transfer the EC, the environment clearance, from the name of the Tahsildar to my name, so that I can carry out. And if your lordship will see the first para, this has reference to your application such and such, wherein you have requested for transfer of EC granted by such and such authority, dated 14/3/19, issued earlier in favor of Tahsildar Lathikata such and such. This, for this purpose, page 34, Millets. Your lordship has page 34.
Yes.
Thereafter, Millets will see the consent to operate also, consent to establish also, which is at page 37. In consideration of the online application for obtaining consent to establish of Messrs. Lungei and Quarry, the State Control Board is pleased to convey its consent to establish under section 25. So consent to establish is also there. Then Millets, consent to operate, which your lordship will find at page 40. The CTO, Millets.
You are referring to page 30.
I
Please
was
come to clause 4
at
page 34.
yes, my lords.
That does not appear to be complete.
This is what we received, my lords.
Oh,
No, page 2 is missing, your lordship.
page 2 is missing. The
Yes, my lords.
annexure 2,
Your lordship is I
the writ application
Ah.
is apparently
Yes, my lords, it's missing.
incomplete in as much as page 2 of the letter dated 28/4/2023 is missing from the brief. So what do you want?
Lords, if your lordship will have it in 2 days' time, or lords on next Tuesday.
Counsel appearing on behalf of the petitioners seeks adjournment so as to bring on record the complete document of the communication dated 28/4/2023 bracketed in 2 series. By filing additional
Memo, if your lordship. Left it.
additional evidence. So is this case on 2 weeks?
Lords, can it be next week,
Let it
17th?
come out.
Item 19.
Very great.
May I please, your lordship. My lord, basing on merit in the NEET UG 2023 examination and choice of institution, the petitioner was provisionally allotted seat in the Institute of Opposite Party number 5 by OJ, opposite party number 4. My lord, kindly see annexure 4, running page 16.
Yes.
My lord, the petitioner was provisionally allotted seat for the course BAMS in the Institute of Opposite Party number 5, Sri Sri College of Ayurvedic, and thereafter the petitioner took admission in the said
Why
college.
provisionally?
Well,
Why your admission was provisional? It was not provisional.
no, it was provisional. Initially, it was provisional, and I took admission.
Why it was provisional? Why not regular?
And there is option for you can freeze it or took admission in this college, because if you choice for further round, then you can take finally you can be selected. And the petitioner took admission. Later prosecuted studies. My lord, kindly see after near about first year study, the OG not approved my admission. On this for that my lord, kindly see annexure 12 page 31. We have got allotment through OJ counseling and not withdrawn from the counseling process till third round. As per NCISM guidelines, they are not eligible for further round. My only mistake is I have not withdrawn after taking admission for further round. I am eligible and I have everything. There is nothing wrong. Only I have not withdrawn from further round.
after taking admission.
Were you informed? Were you informed at any other time that you finalized?
My lord, by the annexure 11, when I came to know such fact, I made a reprehension. Annexure 11, page 29.
So this is a complicated process. And everyone has to satisfy each and every requirement and each and every step. If you fail, then you can happen.
My lord, I have no fault. I am eligible. No way it is illegal or only irregularities is I have not informed after
Whether
taking
that was
admission.
required or not.
That is a formal requirement.
Formal requirement.
Even if after my admission, they verified my document. The college also kindly see Annexure 9.
All right. Who is appearing for the college?
My lords, I have made please, your lordship. My lords, I have the instruction to appear for the college, my lords. But my lords, I don't have the entire copy of the petition. I got a copy from the learned DSGI's office. I may be given at least 1 week time to, because, and in fact, my lords, I verified over telephone. We have not received the notice as on date, my lords. So lordship may keep it to next week. I will take instruction in the entire matter, my lords.
What has happened here? Said, it's a we have stopped only because of the central agency is taking a strong view. Otherwise, my lords, the student is qualified. I have my instructions, but we were forced to stop because that was a lapse in that following that guideline. On the second round of counseling, she was actually allotted the seat in her second choice of college. That is the present college where she has prosecuted her studies for a year. What she has not done, she should have opted out. She should have stopped there and said that, no, I am opting out. And then we would have given her the final allotment. So instead of some problem might have happened, might have not taken it seriously. Must have escaped her notice. I am also making allowance for that. But at my level, I can't do unless your lordships give a direction to the central agency to condone it. So therefore, my lords, we gave her a provisional admission. And after and then we send it my lords admission.
So, but you can file a mild counter affidavit.
I'll file mild counter, my lords. I'll do that.
Study for 1 year?
My lords, I have it ready. I will tone down my. I started on that footing only that I.
File your affidavits.
My lords, it's a genuine student. Genuine student.
Let a copy of the writ application be served upon learned counsel representing the college Nam Dikshana.
Shri
College of Fire.
Opposite part number 5, my lord.
Yes.
Opposite part number 5.
OP5.
My lords. Shri College of Ayurveda. Ayurvedic Science and Research Hospital.
Mr. Subir Palitlan, Senior Counsel, has represented, has appeared on behalf of opposite party number?
OP4. Opposite party number 4. OG. OG.
Assisted by MS Pavita Sahu. Stop. List this case on 2 weeks. Within first 5 cases. Stop in the meanwhile. Let counter affidavits be filed on behalf of the opposite parties.
Assisted by Ananya Pradhan.
Ananya Pradhan.
Ananya Pradhan. Ananya Pradhan. Bhavita Sahu.
The OP2
Yes,
should also be
2
present.
weeks.
OP2's presence would be necessary.
Yes.
Item number 20.
National Council, Commission for Indian System of Medicine should be necessary. Also necessary party. It's at their behest that we have stopped.
Who appears?
OP2. I don't know my.
My lords, for
Central government can appear.
my lords, for OP1 and 2, my lords, the
Probably the
DSJ,
central government.
Already served.
Learned
Central government
DSJ along with Madam Babita Sahu would be appearing, my lords.
Yes, yeah.
My lords,
No, 1 and 2.
One.
no, I am not appearing. I just got the information from them. Madam Sahu has informed me. I will inform because there is. I'll inform. My lords.
Please inform them.
Yes, my lords. Yes, my lords.
Good.
I'm obliged.
Item number 20.
So the petitioners own agricultural lands across 2 stone quarries, my lords. The stone quarries are within their agricultural lands, my lords. And my lords, by virtue of these agricultural lands being around the stone quarries, my lords, if there is any blasting or any stone quarrying there, my lords, all my lands will get destroyed. Accordingly, we made a representation because these are all agricultural lands, so the land would lose its fertility. So we made a representation before the collector that please allot us these stone quarries so that we can operate it and in turn safeguard our agricultural lands, whatever terms and conditions. My lord. These are actually the stone quarries of the Jagannath temple. My lords. So, my lords, that representation was kept pending, and 2 auctions were also, my lords, published. But these 2 auctions were cancelled because, my lords, our lands are across that particular area, and my lords, keeping in view our representation, they have cancelled those 2 auctions. The RDC also, we moved the RDC. RDC also asked the collector and sub-collector to inquire into the matter and to find out if it was possible. We are ready to give any condition, my lords, whatever condition.
No question of condition. See, according to you, your land is situated around the mining area. You objected to the mining operation being given to some any other person.
Well,
they have acceded to your request. They have cancelled the
auction.
Yes. So you should be happy.
No, my lords, what
right do you have?
My lords, I don't have it. Strictly, my lords, I don't have any right.
You cannot maintain your application.
My lords, but by this process, my lords, what is happening? The mafia are entering in the night and blasting there.
That is happening throughout the.
My lords, and on top of that, my lords, the Jagannath temple is also losing revenue. Whatever revenue they ask for, my lords, I'm ready to give.
See, Mr. Kanungo, and you too, we don't know anything beyond Kanun.
There's a go. There's a go after the Kanun.
Yes. So therefore, we are bound by your right is to be determined based on law.
Yes.
We decide cases based on
In
law.
accordance.
So therefore,
Malas, what I'm praying for is let the Jagannath temple at least consider my request, Malas. Malas.
Not to you.
Malas, what Malas, there is a direction of this honorable court for the authorities to consider my representation.
That is the whole difficulty, and therefore, their representation will not do.
You already got an order.
Yes, Malas. That is at running page 7. I quoted the order.
Rejected or still pending?
No, that is pending. That is what we want to dispose of. Malas?
No contempt.
No, Malas, dispose.
And that representation, that order was passed in 2019.
Yes, Malas. Reason not, Malas, actually, Malas, they have sent it for an inquiry. If at all it can be granted to us, they can consider it. Let them dispose of my representation in accordance.
Yes, it be granted when you say stop the mining operation.
No, Malas, what is happening because of unplanned quarrying operations, the entire stone will fall on our grounds. If we do it in a planned manner, it will not come.
Anybody else can also do it in a planned manner.
Malas, they will not do it. Why should they bother about my
Are you
land?
serious, Mr. Kanungo?
Malas,
Are you seriously making these submissions?
Malas, I have to justify my clients.
Yes, there you are right. The present writ application has been filed seeking following direction. Paragraph Roman 1 of the period portion. Oh. Mr. Kanungul and senior counsel appearing on behalf of the petitioner has submitted that since he has land nearby the stone quarries mentioned in the queries as noted above, comma, the lease for quarrying should be granted in his favor. Stop. It is next, it is noteworthy that the petitioner had earlier approached this court seeking quashing of a notification dated 7/7/2018. Court, by filing a writ petition, which had given rise to WPC number 13383 of 2018, seeking quashing of a notification published by the sub-collector Khorda, authorized officer Khorda, to put auction of stone quarries in question, to put putting auction, to put stop. The challenge was mainly on the ground that earlier also, a similar auction was cancelled, considering the petitioner's representation. Stop. This said writ petition was disposed of by an order dated 25/2/2019 by a division bench of this court, directing disposal of the petitioner's representation and passing of a reasoned order. Stop. Next one. Senior counsel appearing on behalf of the petitioner has submitted that the said representation has not been disposed of. Stop. He has also submitted that it would be in the best interest of the lessor and the petitioner also that the said queries are settled in favor of the petitioner, since the petitioner shall be in a position to ensure that the mining activities are carried on in a manner that the land, which belongs to land around the mining site, comma, which belong to the petitioner do not get adversely affected. Full stop. Next. We do not find any merit in this application for the reason that the petitioner has not been able to establish any legal right for this court to issue a direction as sought for by the petitioner. First of all, we do not find any merit in this application, which is accordingly dismissed.
Item 21.
My lords may observe if they consider my request. Obliged.
To summarize the nursing matter, some petitions, 6 petitions, filed by Mr. Das, General Counsel, was served on me on 3rd, and that was the diary number. No WBC number was there, for which I was unable to give them any instruction.
All right, take instructions. When do you want?
Next week, my lord.
All right, as requested on behalf of the DMET, list these matters on 1 week.
Yes, please.
Item
For him to seek instructions and file counter affidavit. if so required.
All the matters.
Item 22.
File counter affidavits if so required. Yes.
Wait, please, Your Lordship. Your Lordship, we have challenged the notification, the validity of the notification that is at page 18 of the brief, Your Lordship.
Yes.
Your Lordship, in furtherance of this notification, Your Lordship.
You are challenging Annexure 1.
Yes, Your Lordship. Annexure 1, Your Lordship. That is a notification by the Home Department, Government of Odisha, Your Lordship. We have challenged this notification, as a result of this notification, Your Lordship, all the cases, Your Lordship, whether they are tribal by the Learned Court of Magistrate or by the Learned Court of Sessions, Your Lordship, they have been transferred to the designated court of OPID, Your Lordship. So a basic basis of challenge is that even if the cases are exclusively tribal by magistrate, Your Lordship, the same cannot be transferred to a court of sessions, Your Lordship.
Right.
Because that is against the provisions of CRPC and the VNSS and the OPID Act itself, Your Lordship. So if I may take Your Lordship.
Show us the provision.
Yes, Your Lordship.
So BNSS will have no application.
No, Your Lordship. Only
All right.
because of reference.
Let us see CRPC and
Yes, Your
OPID.
Lordship. CRPC and OPID Act, Your Lordship. Of the OPID Act, Your Lordship, that says what is a designated court, Your Lordship.
Yes.
Section 8 says, for the purpose of this act, the government may, with the concurrence of the Chief Justice of the Odisha High Court, by notification, constitute one or more designated courts for such area or areas or such case or cases as may be specified in the notification, which shall be presided by an officer belonging to the Odisha Superior Judicial Service, Your Lordship. In this provision, Your Lordship, the important words is that for the purpose of this act, Your Lordship. And subsequently, Your Lordship, in clause number 4, it
See,
says.
madam,
Yes, Your
one
Lordship.
case we had dismissed.
Yes, Your Lordship.
Similar case
Yes, Your Lordship.
where a proceeding before the court was challenged. Do you remember?
Yes, Lord. So my friend, he had the almost same notification was on
Your
the
Lordship, why I am before Your Lordship?
See,
sir?
madam, there is difference
Yes, Your Lordship.
between your case cannot be tried by this OPID Act because the provisions do not apply.
Yes, Your Lordship.
That plea you can take before the court wherever the matter is pending.
Your Lordship, we have taken that plea.
You cannot take that plea here.
Your Lordship, we
You
have,
can file a quashing application under 482. We are not sitting here in advisory jurisdiction to advise you to do what
Your
you
Lordship,
should do or should
Your
have
Lordship,
been
that
done.
is what is my.
But you cannot, there is no legality, no illegality in the notification.
Your Lordship, there is the illegality is that, Your Lordship, I'm losing a forum, Your Lordship.
You may be losing a forum. You may be losing a forum. Have you challenged the validity of this act?
Your Lordship, the act is not saying that every offence that is triable by magistrate will be transferred to
Madam,
OPID
this
court.
is what we are saying, that the only of such offences which are triable by the act are to be transferred to this court. So your case might have been wrongly transferred to that court.
Your Lordship, that is
Sorry,
what. No, Your Lordship, Your Lordship may indulge me for one
Sorry,
moment, Your Lordship.
unnecessary. Don't
Your
waste your
Lordship, that is what that is what was the previous notification. But this notification of 2023 says that every case that is being investigated by the EOW stands transferred, Your Lordship. The notification says that, Your Lordship, dispose of cases initiated by the EOW. And this is a subsequent
minute.
notification.
Yes, come to section 8.
Yes, sir.
As may be specified in the notification.
Yes, Your Lordship. This is not that notification, Your Lordship. This is a subsequent notification of
Yes, there is
2023.
subsequent notification. It also refers to the cases instituted by economic offences wing.
Yes, Your Lordship. But in the provision 4 to section 8 says, Your Lordship, when trying any case, the designated court may also try any offence other than offence specified in section 6 with which the accused may under the CRPC.
No,
So
where are you reading?
Your Lordship, I am reading provision 4, proviso 4 of section 8 of the OPID Act, Your Lordship.
Yes.
Clause 4, Your Lordship. Your Lordship, cases.
Yeah. You can see, file your affidavit.
But
fact,
here,
what-
Lords, my submission is, Lords, this order, this notification be issued in consultation with concurrence of the Honorable High Court, Lords. And Lords, this, in this, by this process, jurisdiction has been bestowed upon the special courts.
See, her submission is that the cases punishable under what are the cases punishable under?
Punishable under the IPC, Your Lordship. Exclusive.
No. What are the cases under the Act? Offences under the Act?
Section 6 of the OPID Act, Your Lordship.
No. Section 6 is.
Yes.
No, forum.
Yes, Your Lordship.
Yes,
Your
same
Lordship, but
ground,
we are not challenging the transfer only because it's a special court, Your Lordship. Yes, Your Lordship. And another fact is, even section 8 does not say.
You can see that see, maybe cases instituted by economic offences wing,
right,
covered by the provisions of OPID Act.
Yes.
Only Either we may have to read that down or you may do something. Otherwise, see, economic offences wing can, and we don't know your constitution of economic offences wing.
It's called economic offences.
So if you can make out a case that the economic offences wing takes up only such cases or all cases covered under this provision are investigated by UOW, then the matter is different.
Yes, but it's a
Otherwise,
specialized agency, not investigating agency. Yes, that we can file not
File
what
your
type of.
affidavit. 2
Your
weeks
Lordship,
time is around for the state to file counter affidavit. This matter on 2 weeks, 4 weeks, 4 weeks.
Your Lordship, I have one small prayer. Your Lordship. Your Lordship, similar situation had arisen in the Ashwini Upadhyay's case, Your Lordship, where cases tribal by magistrate had been transferred to the sessions. Your Lordship, there the Supreme Court was pleased to indulge in that matter.
Transfer is different.
Your Lordship, this is what has happened. The case has been transferred, Your Lordship.
No. This is not a transfer. This is a notification by virtue of statutory notification. This transfer is different, madam. And you are absolutely right in your submission that if the transfer has the effect of you losing a forum, then we may have a case. But if the statute requires, then
Yes,
we
Your
will
Lordship.
see later.
Much obliged. Lordship, there's an interim application.
Well,
May I pardon, item 26 orders, it is listed, directed order reserve, but it has come for orders, tender matter,
All right,
tender
it will-
single bench matter. Item 26, order directed by order reserve, but it is listed today for orders.
Okay, if it reaches, we'll resolve it.
Item 26.
we'll see.
But
We will
it is,
see.
taken up for all order.
We will see. We'll see.
Well,
Madam, I may be pardoned in saying very sir. The Council has been pleased to fix item 44 to at 2 p.m. I have got instead of appearing in 3 cases just now. So I pray some time may be given to me.
No, let
I am for respondents, madam.
we know, but the petitioner has to be there.
So I have
we
taken
don't have any
notice of some
objection.
of the petitioners, my lord. I have taken
All right. We will see. You are for whom?
I am for the one of the respondents, respondent number 4.
We will see whether you are required.
Item number 44.
That is item 34.
Yes.
But the state it is directed against the judgment of the CBI. That quashing the recruitment and appointment of the village agricultural workers, those who have been recruited in pursuance of a statutory rule. But the sanitary ground on which the writ petition has been allowed, that the advertisement was issued by the deputy director.
Yes. Very
Instead
well.
of the director. That they have been working since the last 11 years. 10 years. They are not the parties before the Honorable Single Judge. Their appointment has been struck down because the consequential action has to follow if the advertisement goes. So, and additionally, they say that the deputy director is not the authority under the law. So he has floated the advertisement, so therefore it is to be quashed. That's the sole ground. But we have taken the plea that deputy director is the nodal officer. So far, the appointing authority of those officers are concerned, and on being authorized by the government, expressly authorized by the government. So he has floated the advertisement. So that is the solitary issue which is to be decided whether the appointees will go after 10 years without being impeded as parties, number 1. Number 2, let us assume that the deputy director also, I have to check whether under the General Clauses Act, the director includes also the deputy, because the secretary also includes under the deputy secretary of the deputy secretary. What is the secretary, joint secretary, deputy secretary, that is for the Odisha.
So let us see the advertisement first.
Because the private parties are there in appeal, the selected, they have been working, the employees rather, for last 3 years.
Let us see the advertisement, Mr.
The advertisement Let me first point out will you not look at the rule?
Yes. Where are the rules?
I'm
Giving two compilations.
Rule 5. Rule 5, sub-rule 5, at base 3 of the rule is I've given a compilation. That you may look at base 3, sub-rule 5 of rule 5.
Lord, may I read it, my lord, if your lordship would permit? Mono. Yes,
Yes.
Lord, there is a committee also, the Director of Agriculture and Food Production.
So 5 is the main this thing, subsection, sub-rule 5 of rule 5.
You are right, your lordship is right. Let the Director of Agriculture, your lordship must have gone through it, I'm not. Let the next sub-rule is important because he is not the authority to take the final decision with regard to the recruitment. Let the sub-rule 6. There shall be a selection committee for each revenue district, that is agricultural range, consisting of the following members. Deputy Director Agriculture is the chairman and the convener who has advertised, and the one district agriculture officer nearest to the range headquarters, principal of the GST cage or a senior lecturer instructor nominated by him, and the myriad other members, principal among so and so of Puri region, principal Bolangir, principal of so and so Rangailonda, all other persons, they are the members under the, there is no informity in the constitution of the selection committee, my lord. Admittedly, that's not the allegation. Only exception with the honorable single judge has taken by the advertisement was made by the deputy director, who is the chairman cum convener of the selection committee, not the director. And my lord, after 11 years, the employees around 300 some odd posts, they have been manning the various villages, panchayats, and are working as the nodal officers for carrying out the different developmental works of the government.
When was the advertisement issued?
That was in 2013. I have given the advertisement also.
And when was the writ application filed?
Writ application was filed, my lord, just a minute.
In 2013.
In 2013. After they were appointed. The selectives, my lord, they are the private parties. I think they have also come in appeal. Another
Whether
setup.
the petitioners had participated? The writ petitioners?
Advertisement at page 44, you will also put 5.
No, whether they had participated or not.
They had participated. Some of them participated, some of them didn't participate. They are a group. They are ineligible otherwise, as per the advertisement. There is a eligibility condition which some of them do not satisfy. They may not challenge that the director didn't advertise.
All right. So what is the what is the qualification?
My lord, qualification, your lordship would find the government order. Qualification, six. Relaxation, qualification is not the dispute, my lord, but
No,
still
no.
your lordship would
See,
find.
we have to distinguish.
Right. Your
We
lordship
have to
will,
distinguish
lordship is correct. I am taking your lordship to
those we have to distinguish between the cases of those who were qualified and had applied.
Right.
So against them, you may argue that once they had
Once they
participated
can
in
turn
the
out
process
and
of
they
selection,
can.
they cannot challenge that. Two, those who were not eligible in terms of the rules
Right.
and therefore could not have applied.
Your lordship is
So
absolutely.
they did not have any locus standi to question the
Lordship
advertisement.
is correct.
Two, and three, there may be some of the persons who are parties or not, we don't know, who were eligible,
Right.
but who did not apply. And they
Absolutely.
challenged the advertisement.
Absolutely.
All right.
Three
So
categories.
these are
Your lordship
three.
is correct.
There can be three categories.
Right.
So we may have to find out from them
Right.
as to which
Lord,
category
it would
they
be
belong.
better.
Let us come to the qualification. Qualification.
Your lordship may look at sub-rule 4 of rule 6 at page 5 of that compilation which we
Yes.
have handed over. Criteria for eligibility. A candidate must satisfy the following conditions, namely, so citizen normal, Lord, the resident of Odisha to speak and read write Odia should have passed the test in Odia equivalent the middle school certificate examination standard, should be registered with an employment exchange in the revenue district concerned. That is the district referred to in sub-rule 1 of rule 5, should have strong physique and the etc. Must know cycling and swimming. So the age criteria is between 26 years and over 18 years of age on 1st July of in which the training session is to start. Upper age limit is relaxable by Silka 5 years relaxation they have provided. Applications from government servants who within the prescribed age limits and other qualified shall be submitted through proper channel, etc. Educational qualification. A candidate should have passed the high school certificate examination conducted by the secondary board of examination or an equivalent recognized examination. Application and so on. There is an amendment to sub-rule 4 of rule 6. That is, Millard, you will also could find page 21, Millard. That is not quite legible, but I am taking the pain of reading it. Candidates should have passed. Millard Lordship is difficult to read. I am also finding it difficult. At page 21, your Lordship would find that was amended. The notification number. It is difficult for your Lordship to read it. That is, in 1999, that underwent an amendment, and instead of class high school standard examination, that has been substituted as plus 2 vocational course in the field of agriculture. Vocational course in the field of, page 21 is too small. We have given a compilation.
21 of compilation.
The rules only, rules and the advertisement, etc. Page 21, that is too small. Even if with the help of a lens, it is difficult to read out. I'll give Millard a legible copy, typed copy.
What is there?
Millard, you will also put find a candidate, I may read it, Millard.
Yes.
A candidate should have passed the plus 2 vocational courses in the field of agriculture.
So what is the date of this amendment?
Millard, that is February 19th, 1999. This is a rule of 99 likha hai upare 98. No, that has been published in the Gazette on 19th of
So
just a
whatever.
minute. Wait.
Whatever, that is.
Yes, that is in 99. This is a rule of 1981. So that is much prior to the advertisement.
All right.
So
Who is
therefore,
the
since-
appointing authority under the rules?
Appointing authority, Millard. The deputy director, Millard. Deputy director. I said.
There is no dispute.
There is no dispute. Because it's a district cadre. So he's the,
So it must be there in the rules.
that should be there in the Just a minute. Well, let me just. Criteria, character, reservation, certificate, identity. Each selected candidate will be given a rule 14. Rule 14. As the time of admission, premise shall produce a medical kind.
24B.
Hmm? 24 feet. My lord, great. You are right. Lord, page 9.
Yes.
The concern
23B, 24B.
Clause B of Rule 24. The concerned Deputy Director of Agriculture, that is the range, my lord, shall be the appointing authority of the VAWs. So he is the authority who has added. I am grateful to you, lord. This is very pertinent point. The grounding.
Yes.
Selection, he is also, my lord, the chairman of the selection committee. Under Rule 5, I read out that.
Very importantly, if this comes to case 4, application response to the other side, address to the director.
And also.
So there is no dispute. Just so, Lord, admittedly, the deputy director is the appointing authority. He is the chairman cum convener of the selection committee. And also, my lord, he is the controlling authority of the entire VAW.
Yes.
So he has advertised. So two questions arise whether that golden principle is there. I am conscious that the statutory interpretation, if the power is conferred, but so once, my lord, that this principle of equity and acquiescence may arise after 10 years, if there is a challenge and they have already served a considerable period of time in the cause of the establishment, whether that can be disturbed. That is also a larger issue which is to be addressed. So, my lord, it is better that if I segregate. So what are the, because none of the selectees, appointees, they have been made parties in the court before the Honorable Single Judge. So some of them have come in separate writ appeals. So if your lordship would permit, I can make a synopsis and date chart. And a short date, your lordship can fix next week any day.
So the candidates who were selected were not implemented in
the writ petition.
And the persons were appointed as on the date of filing of the writ petitions.
They were not parties.
Oh no.
Sorry, Miller.
They were appointed or not?
Yes. They were appointed. They were appointed. Continuing.
They were not implemented, but some of them had intervened.
Intervened.
That has to be. So some of us had intervened before the single.
But not all.
Not all. Not all. Some of them had intervened.
If you lordship kind permission, since the advocate the addressing on the rule, say, look, there are two other provisions of the rule. So far, deputy director is concerned. Because you are also looking to the rule. You also look to 510. 510.
Everything is deputy director. Rule 8 also character.
Original application of the selected candidates shall be sent by the range deputy director to the principal. Then you also look to next page, Rule 7. Rule 7.
No, everywhere it is deputy director. Why is some
application
Rule 8 also? Just a minute. Rule 8 will so far the character
There
is
are
concerned.
two crucial aspects. One, that Rule 5 is very clear. It says that advertisement ought to have been by the director. And two, the appointing authority is the deputy director.
Deputy director.
There are two aspects. One, that the deputy director being the appointing authority, whether he could have gone for the advertisement or not. Two, whether advertisement having been issued by the deputy director and not the director, the advertisement itself can be said to be per se illegal and vitiating the entire selection process. think this is these are
Just
two basic
Listen
questions.
to the proposition, we'll answer.
And other aspects also, that whether the petitioners, writ petitioners participated in the process of selection, they could
Right.
challenge the process of selection. These are the, I think,
Here
main-
is
These
also-
are the points too.
Here is also admitted fact as rightly said by Lord Advocate General. State has given the permission and the
So that
director
aspect,
has also
let-
yes, that is there.
state has given permission.
Yes.
State means what?
State, the government,
Agriculture Department.
the government, the agriculture department.
See, the director is, the position of the director is statutory in character in terms of the rule. So neither the chief minister and not an officer below him could have issued the
No, your
advertisement.
lordship is correct. I can understand the principle. If
All
the
right.
power is
It
conferred,
was, power was vested in him if it is your stand
right.
that the advertisement was issued with the approval of the director.
But yes,
Yes.
yes.
With the approval of the director.
Lordship is correct.
Then the
Scenario would change.
That is-
Suppose,
that is-
my lord, your lordship is correct.
and even if the advertisement was issued under the signature of an officer not authorized, whether that can be basis for the entire selection process
Right.
being vitiated.
That would have been a different scenario altogether. my lord. Suppose there is no express authorization in favor of the person who went for advertisement, my lord, that would have been a different scenario altogether. But the government's authorization in favor of the deputy director would make it, because the rulemaking power is vested with the government. It's a 309 rule. Huh? Director. Yeah, the government authorization. Lord Lordship would look at page 26.
Yes.
26, my lord. Of that compilation again, my lord.
Yes.
This is a 2008,
2000?
2008 notification of the government.
Yes.
It's a government notification, my lord,
Yes.
addressed to the Director Agriculture. Decision of Government in Agriculture Department on the orders passed by the Honorable High Court in WPC number, what is this case? Just a minute. On matters relating to engagement of VAW, LVAW on contractual basis. I am directed to invite a reference to your letter number so and so on the subject noted above, and say that after careful consideration, government have been pleased to pass the following orders in the aforesaid matter. If percentage of marks secured by the candidate in +2 science, similar, that is the how weightage is to be given to the candidates. And marks secured by another candidate in +2 vocational course in the field of agriculture.
So these rules were framed in exercise of which power?
That's 309, I think.
No.
Then rules, rule by order of the government, rule making, then it would be, how can I achieve? Rule making power is there. Every orders are to be expressed in the name of the governor. So, but this is not a civil post, my lord.
Are you sure?
It's a, the governor of Odisha is pleased to make the following rules for the recruitment training of village agricultural workers. Called the recruitment and training of village agricultural workers, and they will come into force at once, the constitution. All rules, instructions hitherto in force pertaining to the subject matter of these rules are hereby repealed to the extent they apply to the VAWs. In these rules, the context, but I have to check this, how this, I have to check, taking constitution. Check. I have to check this. 166. Article 166.
So whether these rules have are statutory?
This is statutory. It can't be non-statutory. Once a rule has been framed, whether it has been, but I'll check this. It's a matter to, I have to inquire. So, my lord, otherwise, my lord, if there is no rule, this full recruitment is to be otherwise, my lord, from that angle, I have to examine. I'll ask the officers, I'll verify from the Secretary Agriculture. But this
And how do you say that
309,
these posts are not civil posts, not a civil post?
all executives shall be.
Are you
express
sure?
statement.
No, all right. All right.
My lord, 166, if your lordship would look at the conduct of government business, all executive action of the government of the state shall be expressed to be taken in the name of the governor. Orders and other instruments made and executed in this shall be authenticated in such manner as may be specified in rules to be made by the governor. Let's may look at sub-article 2 of Article 166. So even if it is not to be construed as a 309 rule, so 166(2) also authorizes the government to make notification rules. So I have to check this. 166(2). Orders and other instruments made and executed. All executive action of the government of the state shall be expressed to be taken in the name of the governor. Orders and instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor. And the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed.
See,
by the
166 has a limited scope.
That is
166 deals
shall
with
make rules.
executive actions of the government.
The third, the governor shall make rules for the
So
more
that is rules of
convenient
executive
transaction of the
business.
business of the government of the state.
Mr. Acharya, this sub-rule, sub-article 3 refers to the rules of executive business.
Executive business.
The governor shall make
No,
rules
your lordship is
for more
correct.
convenient transaction of the business of the government.
Your lordship is correct.
So this is not, and if any order is, if any action is taken under Article 166, that is
No, my lord, the
executive.
subsequent government order, if I justify that, the government authorizing the deputy director, let the state government authorizing the deputy director, my lord,
Oh.
that may be.
That the Mr. Acharya, the question is
My
whether the rules which have been referred to
lord.
are statutory in character and therefore binding on all courts or not, or whether they are mere executive instructions.
My lord. Correct, correct.
All right. If they are statutory in character, then they must they must be based on some statutory provision, either
Right.
constitutional
Right.
or any other statutory provision. So the rules do not refer to Article 309. All right. If the rules are, you can say, executive instructions in terms of Article
No, I have to
166.
see if there, my lord, two things. If they are, my lord, posts in connection with the affairs of the union appointed to public, it's a post, contractual. No, contractual. Regularized. So if it is a civil post, my lord, this 309 will come to play. So I have to check.
No,
They
that
say-
has not been stated. Come to at the top of the rule.
The rule that doesn't say it is 309. But my lord, even if it is not stated in the rule, your lordship knows,
All
there
right.
are also judgments.
All right.
Suppose it has not been referred to, it is a 309 rule.
Yes.
So that would not vitiate the rule. So if the power is there, my lord, for framing
That
of
will
the
not-
rule. Yes.
We are not saying that that will
No,
vitiate.
your lordship is correct.
But we are saying that we have to test it.
Test.
The
No, lordship is correct. I got that point. Non-description of a particular provision.
no,
even
no,
if
we're just trying to
Find out.
evaluate the character
my lord,
of
no, lordship
of
is
this
correct.
document.
Lordship is correct.
A law,
Right.
either this thing, the act,
Right.
or any subsidiary law, those are binding. So for
Right.
form of law.
My lord.
So if these are rules, these are statutory rules, they are binding. Otherwise,
Yeah,
if they are
the competency is one aspect, whether the government is vested with the power of rule making or not, that is one aspect. So it is whether it is within the competency of the state to enact such a rule or frame such a rule.
competence is not in question. The question is, which power the government was exercising
Right.
while framing these rules?
The rules.
Where constitutional power under Article 309
Right.
or executive power under other provisions of the
166.
Constitution.
Right.
Right. So therefore, whether these are executive in nature or legislative in
Right,
nature,
right.
it's a subordinate
I got that one.
legislation.
I got that.
All right.
Similar what I was proposing. Second. So let me just make out the category and classification of
Yes.
the petitions.
Yes.
And under the various questions your lordship have put, I have to address also. So let it be kept to at
No,
2
let
PM.
us have their views also.
Right.
The who are you? Who are the respondents?
I am for one of the appellant and also respondent in other cases. I filed an independent appeal challenging the order of the London single judge because they have only awarded 5 lakhs rupees. They have not considered our service conditions. We have appellated one. In other matters, minus
All
some
right.
respondent.
So one question.
Yes, ma'am.
You are appellant in which case? Appellant in W.
I think that has not been listed today.
A number.
2910-2023, I am respondent.
How much do you want?
My lord?
Oh, you don't want money. You don't want money, you want post.
We want post. That is why we filed that one.
How many?
Minus 4.
4. So whether you had applied against the advertisement or not?
We are not, minus, we are not permitted to apply.
Why?
Because, my lord, the advertisement did not indicate about our qualification.
Qualification was not, you had the qualification.
We had the qualification of +2 science, +2 arts or science, whatever the subject they wanted. But in the advertisement, my lord, the date they have not been extended. I will explain it, my lord.
No, let us understand first the basic aspects we should be clear about.
Your lordship can have a look. There is a
Just a minute.
direction given by the court.
Just a minute. When was the advertisement issued?
Annexure 3 may kindly be.
Date.
Date is, my lord, 14th of August 2008 is the first judgment of the Salwar Court, wherein a direction was given.
Advertisement. What is the date of advertisement?
Date of advertisement, my lord, that first date of advertisement is 18th of May 2008. This advertisement was challenged because it was not inconsistent to the rules.
All right. Now, do you have the rules?
Yeah. My lord, according to the rule, they must have a qualification prescribed of the rule that was not contained in the advertisement.
That is not required.
And this Salwar Court decided that, my lord, at page 42, dated 14th of August 2008, that the advertisement issue is quashed with a direction that you are to give a phrase curriculum to the advertisement, fix other dates. Fix a later date for other persons who can also apply and participate in the selection.
Where is that?
That was on 14th of August 2008.
Where is that?
My lord, Annexure 3 at page 43 in 2910 of 2023.
Whether that is there in the compilation?
Yes.
That page 22 of that compilation.
I'm going to compile something. Achha.
Yes.
My lord, in spite of this order.
Just a minute. Yes, what is there?
Your lordship can have looked that the advertisement initially was issued by the director food agriculture and food products. Advertisement dated 18th of May 2008.
So this was the stand taken by the state government in the earlier litigation, that the rules were framed by the government of Odisha not under the proviso to Article 309 of the Constitution. The division bench, however, has recorded that still the rules are binding.
The observation was, my lord, that
All right, so.
my lord,
subsequently-
paragraph 13 of that order.
Yes.
May I place it, my lord?
We
Paragraph
have
13.
seen, we have seen.
We are satisfied that the rules that have been framed by the government have not been followed.
Yes.
And thereafter, my lord, in spite of accordingly, the read application is allowed, the advertisement and answer to is quashed to the aforesaid extent. The opposite parties are directed to issue a corrigendum to this effect and fix the last date of application afresh, issue urgent certified copy. That means that part of the advertisement which indicated about the qualification, that was quashed, rest of the advertisement remained as it is. In spite of this order, my lord, instead of issuing a corrigendum to the as directed, they issued a fresh advertisement.
Yes. Yes.
That was challenged. The fresh advertisement was challenged, my lords. That was order passed on 3rd of February 2012, page 48. And it tell me what is comparison.
Page advertisement is page 27 and the judgment is at page 28. That's my compilation.
Yes.
This honorable court, my lord, took amidst of this advertisement. Your lordship can have a look, 51, paragraph 6. What this honorable court observed.
In the impugned judgment.
Yes, my lord, judgment next to
Impugned judgment.
No, my lord, before that in 2010.
This is the second judgment of this honorable court, where the honorable court has categorically directed that we are constrained to observe the action of the Secretary Agriculture is not only contrary to the rule, but also contrary to the judgment rendered by this court in WPC, this etc. While we propose to impose etc. my lord, so far as the age of petition is concerned, if they apply, their cases should be considered for relaxation. This, after this, my lord, the third advertisement came, that was on 4th of October 2013 by the Deputy Director. All advertisements were by the Director. For the first time, my lord, the Deputy Director issued the advertisement on 4th of October 2013. This advertisement was challenged, and that was challenged before the State Administrative Tribunal.
When?
My lord, this was challenged on, the order was passed on 9th of December 2013.
9th of December.
2013. And
9th of December 2013, what happened?
my lord, the London Tribunal passed an interim order to the effect that, however, so far the interim period is concerned, since the advertisement has already been issued and many candidates must have applied to face selection for test. So for selection test to be conducted, result to be published, but no appointment be made without the leave of the tribunal. Thereafter, my lord, this came on transfer. This was decided last on 25th of December 2014.
Decided by?
By the tribunal, my lord.
Yes.
My lord, the order, in view of the submissions made by the Learned Council for both the sides, the interim order passed on this days is modified to the effect that the leave is granted to the state respondent to issue appointment orders in respect of selected candidates, but such appointments shall be abide by the result of these OAs, and this shall be reflected in such appointment order. This was the order passed, interim order passed by the, modified by the Learned Tribunal. Ultimately, my lord, that has come on adjudication by before this honorable court on transfer. And that order is, my lords, at page 77. And this has been challenged in writ appeal here.
So whether pursuant to the advertisement you had applied or not?
Advertisement, my lord.
Whether you had applied or not?
My lords, we could not apply because the tribunal gave that we have to apply to the state government to condone our age, because in the next the press advertisement.
You were disqualified by age.
Yes, by age, my lord.
Yes.
Therefore, my lords, the appointment that was given to those people, they say that was subject to the result of the writ application. No regular appointment has been issued. Now this has been decided by the Honorable Court that the appointments are not to be given, or they are not to be treated as regular appointees. Therefore, they have challenged in the writ appeal. We are challenged that though we are eligible for appointment as per the qualification.
So who are the persons who had applied? There is no party.
My lord, so by that time there was no party, because it was not considered who applied and who did not apply. They did not incorporate themselves as opposite party. Intervene, they did not intervene.
No, because here who are the respondents? Who were the writ petitioners? How many writ petitioners were there?
My lords, we are only 4 petitioners. I do not know who are.
Altogether 4 petitioners.
4 petitioners before the Learned Tribunal.
And how many posts were advertised?
Advertised post, my lord, was initially. One second, my lord. 323.
In respect of Balangir, 107.
Yeah, total advertisement issued by the director is 312. We belong to Balangir district according to the, as my learned friend was telling, Balangir district.
So what was
Was
the ground,
14.
What was the ground of challenge?
by us. We challenge that we should have been given, because we qualified, others are not qualified. They could not have applied. Those who have been selected, they were on a conditional appointment. So since we are having qualification, we should be given appointment.
No.
Before the tribunal, we had that prayer.
You were challenging the advertisement.
Yes, my lord.
On what ground?
My lord, first is that the qualification that was prescribed under the statute was not incorporated in the resolution, in the advertisement.
Which advertisement? 2000.
And though this honorable court directed to incorporate it by way of curriculum, they did not put that qualification in the advertisement.
See, there was an order for issuance of corrigendum. Instead of issuance of corrigendum, they came out with a fresh advertisement.
Yes, ma'am.
You have grievance against that also.
Yes.
That they should have come out with the with corrigendum and not fresh advertisement.
Yes, ma'am.
This is for the reason that because of the fresh advertisement, you became disqualified in terms of age.
Yes, ma'am.
This was your.
If the curriculum would have been issued, my lords, those who have applied, they could not have applied, they could not have been selected because they do not come within the qualification prescribed under the statute.
All right. So suppose an advertisement is issued in a particular year and the employer decides to cancel the process of selection, to cancel the advertisement, and later a fresh advertisement is issued. So can persons claim that had that advertisement been there, I would have fulfilled the eligibility criteria
in terms of age.
In terms of age, and therefore two submissions can be made. That I would have qualified, we would have qualified, and second, these persons were underage when the first advertisement was issued. Well, therefore, the advertisement is bad. So, second advertisement. Can this plea be taken?
No, my lord, because the honorable court directed, this honorable court directed that you issue a curriculum and allow the candidates, those who have crossed their age, to apply, getting permission from the state government. That was the direction.
So they said you apply to the state government and it will be considered regarding the age.
We have applied, but
no, not that. What was the direction of the court?
My lord,
the direction of the court was not to issue a corrigendum in respect of age.
Yes, my lord.
It was probably that you will approach the state government and they will consider.
Right.
Your lordship, may, at the cost of paragraph 13 is the operating portion. Paragraph 13 is the operating portion.
That was considered and rejected, not just for two steps.
Let us clarify what was the order and what they did and what has happened there. Yes,
paragraph 13. We are satisfied that the rules have not been framed by the government, have not been followed, and the advertisement has not been made in consonance with the provisions of the aforesaid rules. Therefore, in your considered opinion, the rules framed by the government, that is recruitment and training of village agricultural workers, rules 81, and amendment by notification dated 24/6/1991 are applicable to the cases of recruitment of BAW, LVAW on contractual basis. Accordingly, the writ petition is allowed. The advertisement announced to is quashed. To the aforesaid extent, the opposite parties are directed to issue curriculum to this effect and fix the last date of application afresh. Issue urgent service. Therefore, they are to make a curriculum. They are to make a according to that last date of application is to be fixed, so that the persons, those who come within that, they can apply. That they did not do.
What about the order in 18942 of 2008 and batch?
That batch panels is from different districts, because they issued advertisement by district wise.
This district was that you apply to the authorities.
I applied from the Balangi district.
earlier this, I may permit it, my lord, earlier this was on terms and condition that he must have registered his name at any of the employment exchange under Keonjhar Revenue District, so as Balangir Revenue District. So it was district wise. What they did, instead of issuing a corrigendum, they have changed all terms and condition and issued a fresh advertisement and stating that we have incorporated that what has been directed by this honorable court. First of all, my lord, without issuing a corrigendum, a fresh advertisement repeatedly tinkering with all the orders of this honorable court is maintainable or not. And they have, when there is a corrigendum, other terms and conditions are intact, but they have changed it.
Your turn will come.
My lord. I am for Keonjhar. My learned singer is for Balangir. We are only 8 and 10 persons waiting for appointment.
No cash for this.
You had applied.
My lord?
You had applied.
No, my lord. Our case in 2013 have been rejected on being overage because that is I have annexed in my writ appeal.
The learned single judge has interfered with the advertisement mainly on two grounds.
Yes,
Firstly, that
one point, my lord. The Lorraine Tribunal, while disposing of the original applications on 9/12/2013, at page 64 has observed as follows. In case the applicants succeed in these OH and are entitled to consequential appointments, junior most of candidates selected and given appointment shall have to make way for the applicants. Therefore, my lord, if anybody who
can they make way for the applicants who had not participated in the process?
my lords, because I understand the difficulty as the question is put, but the problem is, my lords, we could not apply because our application.
That is different. But there is the question of making way. This is the question of making way. Matter would have been different had you been permitted provisionally by the tribunal to participate, subject to final outcome. That would have been a different situation altogether.
That is what, my lord, we challenge that matter in the writ petition that was disposed of by the honorable single judge with that observation. Probably the honorable single judge thought that we are not given the benefit, so we should be awarded 5 lakhs rupees compensation.
How much do you need?
Because we are the
and by which process you can be given appointment?
My lords,
applying which law or rule or whatever? Whatever.
If the selection was to be made in accordance with the advertisement, according to the qualification prescribed of the statute, my lords.
All right, what do you get more than the compensation?
We are the eligible persons, why could not we get it?
Maybe lakhs of persons may be eligible. That's the difficulty. Let us see. Yes, madam. Now.
Well, I'm appealing for Kenjal. My learned senior is overaged by that time, but my
Senior
client.
is not overage. The clients.
Sorry, my clients are overaged.
Yes.
By that time.
Yes, he's right, my lords. I'm also overaged, so far the profession is concerned. I have crossed the age.
That's my bad. That's my mistake.
He is working not less than 10 kilometers a day, Mr. Rath. And he never works, he runs in the court.
I don't feel overaged, but since my friend says that I'm
I'm not.
He's rather getting younger day by day. And is not.
That in Balangir district, by that second writ application where this honorable tribunal.
So what is your submission beyond what has already been submitted?
My lord, my submission before your lordship, we the petitioners before your lordship were within the age at that point of time. And even corrigendum would have been issued, then we could have been, we have selected by the first advertisement 2008.
Therefore, you were denied.
My lord.
All right. That's all. Whether you can be appointed is a question.
Yes, my lord. Because they have stated, my lord, my submission before your lordship, they have formulated a technique so that these petitioners, those are fighting the cases from 2008 to 2013, would be not come under consideration. That was the technique adopted.
Therefore, no, they might have adopted incorrect technique or wrong technique or technique just to keep you away from the process of selection. But what do you get?
Because my submission would be, my lord, if that third advertisement would be declared totally illegal because that is in gross violation of this.
What are you getting?
I can be, my lord, considered by the government to get appointment. Huge vacancies are there. Huge vacancies are lying vacant, and we are eligible at that point of time. Due to this multiplicity of proceeding, we have denied that.
If there are huge vacancies.
My lord.
And it is directed that your age relaxation can be considered by the government favorably, then you will not have any grievance. Madam, the whole difficulty is that the court cannot direct your appointment in any case, because unless you undergo the process of selection, you cannot be appointed.
But their illegality, my lord, court can say them to protect everybody. Let them, because that is a condition. They must belong to a family of marginal farmers. Nobody is, my lord, that is of a rich or something. They are all are for poor family and marginal farmers. And they have made it, they changed total terms and condition in third advertisement. Because my lord, corrigendum is to keeping all the terms and condition intact. You can modify the error, what is happened in the first advertisement. What they did, they changed totally the terms and condition in third advertisement, input advertisement before your lordship, make it for whole Odisha, so that we people, we are fighting for 2008.
So you wanted that the selection process should have been confined to Bolangir?
No, that was there
Or
in the
in your
first
case?
Bolangir and Keonjhar.
No, then that was illegal.
Madam, that was the
That advertisement was unconstitutional.
That
So they rightly came out with a fresh advertisement.
Yes, 2008 advertisement. When there is a corrigendum is to modify the error. That they have not included the qualification.
No, see, the direction to issue a corrigendum will not amount to restraining the state respondents from undoing something which was patently unconstitutional.
But where is the corrigendum? They have never issued it.
So what?
So we are all age bar. So we are not. And this honorable court, my lord, in strict things they have stated. This attitude of secretary is, my lord, that is the second
Judgment.
Second judgment, my lord. Kindly refer to that.
We have to determine
My lord.
their rights of appointment based on a selection. Based on an advertisement, according to you, issued by a person who was not competent. And your right to be appointed because you were not considered for appointment. These two things are to be balanced. No?
Illegal selection process, my lord. We are saying totally illegal selection process, unfair, arbitrary, because they have not respected the order of this honorable court. And they have made us. And they very well know that, because the tribunal made it, my lord, at that point of time, contractual is the norm of appointment. For that, we have come in 2008 and 2010. In 2012, this honorable court directed, no, it is not being not a civil post, you are go before the tribunal. That's why for the first time we are before the tribunal in 2012 and for 13 for the said impugned advertisement. And the tribunal given an interim protection, but it is
that has been argued by Mr. Rath.
And this honorable court directly in 2008 and 10 asked for the corrigendum.
Those aspects have been
So
addressed.
these, we are only 8 and 10 petitioners are fighting these cases for so long, my lord, 2008. And we have been overaged by the 2013 because all the terms and conditions have been changed by 2013. And they are being not complying the orders of this honorable court and getting everything. My lord, we are fighting and we are last finally, and we are not been protected. Then your lordship may say that now huge vacancies are available. Let them continue. Let they appoint us also, because it is their mistake of the state government.
They cannot appoint you. They can allow you to participate.
We now not able to.
Yes, can you consider?
That I have to check with the department. I can make a concession. So let me just.
Only 4%, so far as we are concerned.
We are also
16 vacancies are there.
I can't make such a concession
Yes,
without
I know,
the
I know.
instruction.
I know.
Let it come next week. Let me discuss. Then those, my lord, that is again subject to fulfilling other conditions. That is, my lord, age aspect is one. My lord, it's.
Have you taken the money? 5 lakhs you have received.
No.
That has been stayed. 5 lakhs my lord, who will be the officer.
That is why state has challenged that order.
A little bit, some additional. So far as the curriculum, my landfront says that curriculum has not been issued, but the subsequent advertisement has been issued, incorporating whatever the amendment was made as per the rules that has been incorporated. That. So far they are concerned, their age bar. So far the age bar, you also rightly pointed out that that will be considered by the state government. And the state government has considered and rejected. And so far
Rejected.
Yes.
That
Yes.
has not been challenged.
Rejected.
They have not challenged.
They have not challenged
been
that. That part.
challenged.
They have
No,
not
no,
challenged that.
I am not rejected, my lord.
You have not applied.
No, we have applied, we have also rejected, that is in my retopil I have given.
Then did we challenge that decision of rejection?
Yes, sir, challenged in the impugned order, my lord, that 2013 advertisement. Baba rejection हुआ को मना करती हूँ।
That has been rejected. My lord's
Rejected,
sister
not
wants.
Well, so far as Keonjhar is concerned, there are 4 petitioners before the learned single judge. All of them have participated in portions of the advertisement issued in the year 2013. All have been rated to be lower in merit. That is what the learned single judge has observed in the order while disposing of the writ petition, that they are disentitled to get this compensation of 5 lakhs because they had appeared in portions of the advertisement and failed on merit vis-a-vis the candidate who have been appointed. So in respect of Keonjhar, all were eligible. They had applied, and this is their application form. My lord, I will file an affidavit.
She is representing Keonjhar.
She is representing Keonjhar.
She does not have any case.
But they are the interveners.
So that was also the ground taken by me before the learned single judge, specifically that the writ petition at behest of these persons are not maintainable. But the honorable single judge has not dealt with that and has disposed of my case in the light of the observation made in the Bolangir case, making them disentitled to this compensation amount of 5 lakhs and interfering with the advertisement, whereby we were around 30 some odd candidates who have lost our job. And that is because of your lordship are protected by your way of interim order, we are continuing.
My lord, to answer my learned friend, my lord, in government they have filed the writ appeal. In para I, they have stated these petitioners who were either ineligible and had never applied for the post in my case, PAW pursuant to the advertisement. This is the government writ appeal I am reading, my lord.
Forget government writ appeal. You make your statement on oath that you had not participated in the process of selection. Can you say that?
Yes, my lord. I have in my writ appeal I have stated, my lord. In 2711 they have rejected my case, annexure 3, page 63. The government has rejected already.
You are Keonjhar.
Yes, my lord. Only 4 persons.
4 persons.
My lord, we are eligible.
You are?
We are eligible at that point. Eligible, and we have the qualification.
So whether you had applied or not.
My lord, 2013, as per my instruction, I have.
No question of instruction.
No, I have filed a writ appeal, my lord. That they have rejected. I have also filed a writ appeal. In Keonjhar case, my lord, government.
What is the document before you?
My lord, the select list is already on record, and these are the application. My lord, these are the individual application of all 4 persons.
Madam, I have always considered you to be a very responsible lawyer.
My lord, I am saying, my lord.
These are the application, of course, in vernacular.
Deputy director is from.
And all 4 applications are there. And annexure B by 4 at running page 114 is the select list, where their name find place.
That principle also, even inclusion in the select list doesn't confer any right to
No, select below in the merit.
Below in merit.
My lord, whether at that point of time, deputy director is from Kendrapada, all interveners who are appointed are from Kendrapada. That is my. I don't want to go to that side. So they have. My lord, this is the annexure page 63, my lord.
Don't let us confine.
My lord, once government has rejected my case, we do overage.
Madam, please answer to our query.
My lord,
Whether you had applied in 2013 against 2013 advertisement or not.
My lord, that I will.
Where is the question of that?
These 4.
These 4, they were writ petitioners before the honorable single judge.
As per.
Please make a fair statement.
No, I don't know, my lord. If I will take instruction whether they have applied or not, but whatever the document in the record till today, their case has been rejected by the government on 27/11/2013.
Maybe the document But he is referring to the merit list also in which your names figure.
Right.
My lord, kindly see this also, this document also, my lord. This is where they have rejected all the 4 persons case.
What is that?
Overage on
Overage
27.
here.
How can they have rejected it? I am saying, my lord, they have rejected. On
That
Why
means-
are you saying
That
that?
means you are a candidate.
My lord, they have rejected on 27/11/2013 due to overage.
All right.
That's why we are saying that if corrigendum was there, our age would be within the terms and condition. That is, my lord, this is the document they have rejected.
All right, we will see. Yes.
My lord, I just wanted to draw, my lord, certain factual things. In the earlier second round writ petition, there are a part at flag, this is for Bolangi, flag F, my lord may see, of the first writ appeal. The writ petitions we have produced, this is for the second round order of the Honorable High Court. If my lord would see page 23.
Page
On
23 of?
Page 23 of the additional affidavit at flag F. In writ appeal number 2910 of 2023. All the prayers have been mentioned.
Yes, sir. Like F.
Flag F. Now, if my lord would see page 23, page 45.
Flag F.
My lords.
Of the
Flag F of the additional affidavit.
Affidavit
in WA number 2910 of 2020.
Yes.
So there is an independent prayer in all these writ petitions. I'm just placing that prayer number 7. Further pass appropriate order directing the opposite parties to relax the upper age limit for recruitment to the post of VAW, VLW and relax the age of the petitioners for recruitment of such post of VAW within reasonable time to be fixed by this court. So these writ petitions had this specific prayer. There was also a prayer to issue corrigendum, prayer number 5 and 7. Now, vis-a-vis these prayers, this honorable court at page number, in the writ appeal, it is a part of the records, page number 51, the order begins.
51 of?
First writ appeal only, the main writ appeal, 2910 of 2021. Vis-a-vis such prayers, this honorable court gave this specific direction at page 53, paragraph 9.
Yes.
Paragraph 9, so far as the age of the petitioners in respect of WPC number so and so is concerned, it is open for the petitioners to approach the authorities in this regard, who shall consider the same to the fact that the advertisement to the post of VAW has not been made for the last 17 years. So far as age relaxation, there was a specific prayer, and this is what the court said, leaving it to the government.
So whether in the second order, there was any reference to the corrigendum and requirement of issuance of corrigendum?
No. That was a specific prayer in the writ petition, but there was no such order. It simply quashed the advertisement. So that is what I wanted to show to your lordships. That there was a specific prayer in the writ petition, and the court has passed this order. So now they cannot travel beyond this order. And possibly what the Honorable Single Judge has done, it has traveled beyond the second round order of this Honorable Court. This order attained finality. So far as age relaxation, they didn't take it any further. So far as issue of corrigendum, they didn't take any further. So now possibly this impugned order.
Is this your submission that it is hit by constructive res judicata?
Yes, my lord.
The plea was raised in the second writ proceeding.
Yes, and those
reference to the
principles will
corrigendum.
apply. My lord, that is precisely what I am trying to hint at. And my lord, even though strictly those that will not apply, those principles apply. If your lordship wants, I'll give those judgments.
Yes.
So possibly the impugned order couldn't have gone beyond the second round of writ petition orders, especially when their prayers had those express prayers, issue relaxation, issue corrigendum. Those two prayers are prayer number 5 and 7. We have given the entire certified copies of their writ petitions.
Let us see the second judgment.
My lords, that begins from page 51. I'm sorry, my lords, page 48 of the first writ appeal.
We have also given it in the compilation that would be.
Entire complication has been created by government. Had they strictly followed the rules or whatever, these things could not have happened. Yes.
Now, my lords may kindly see page 48. My lord has already seen this when my learned seniors were appearing.
Yes.
And here, your lordship may kindly see state stand is at page 49, paragraph 4.
Yes.
And then paragraph 5, the first round order has been quoted. Then page 51, paragraph 6. And the corrigendum was only for grant of preference, which was complied with. And paragraph 7, they record this. So now what I am trying to contend, my lords, is paragraph 9, the issue of so far as the petitioners are concerned ended here, because their prayer for age relaxation was not allowed and it was left to the state.
They have not questioned that.
So once it was left to the state with these observations, now there cannot be any further directions visa that would be possibly encroaching upon the division bench order of the second. And then this writ appeal also contains the express permission of the director. If your lordship would allow, I'll show those pages to issue this advertisement.
Where is the Yes.
Now, my lords, one more thing was that permission was there regarding the delegation of powers by the director.
Where is that?
That my lords would see at page 55, annexure 6.
Here.
Now, here, this document would be very crucial in the context of 3 judgments of the Honorable Supreme Court, where they say
No,
that
which
my lord may see the document. It is at annexure 6, page 55 in the lead writ appeal. 2910. Annexure 6, my lords. Wherein the Office of the Director of Agriculture Food Production writes to the Deputy Director of Dhenkanal, Bolangir and Keonjhar. So both are covered, Bolangir and Keonjhar.
So this is of 13/9/2013.
My lords.
And date of advertisement is?
Date of advertisement, my lords.
4/10/2013.
4/10/2013, page 57. Just after that document. Now, the contents of this letter also would be important in the context of 3 Supreme Court judgments, which I'll give, which say that if the director completely monitors his essential functions, then that kind of delegation is permissible.
So he was directed to the director directed the deputy director to publish the advertisement.
Yes. My lords.
So therefore, that is an advertisement issued by the director under the orders of the director.
My lords.
And government has also said that mechanism.
And my lord may see at page 56, the last date. So he's monitoring it. It's not that he has delegated his essential functions. That is what the Honorable Supreme Court says, that if there is delegation of essential functions, then maybe it may be hit. But suppose he's monitoring it and there's a permission, he's given all directions.
Yes.
Then that would be good enough. I'll give the 3 judgments. And my lords may kindly see.
Do you have the citations?
Yes, my lords. Writer, I'll give the copies.
Just give it later.
The first one would be 2014 16 SEC 248.
Yes.
My lords, paragraph 2, what they discuss what is meant by delegations, and then the lexicons and all they have been discussed. I'm skipping that. Paragraph 2, then paragraph 3, they discuss Gwalior rayon silk manufacturing.
Yes.
And they basically discuss what is meant by delegation in para 3. Para 4 would be important. I'm just placing that. There is a subtle distinction between delegation of legislative powers and delegation of non-legislative administrative powers. As far as delegation of power to legislate is concerned, the law is well settled. The said power cannot be subdelegated. The legislature cannot delegate essential legislative functions which consist in the determination or choosing of the legislative policy and formally enacting that policy into a binding rule of conduct.
No, but this is delegation of legislative function.
My lords, later on they discuss about administrative.
Yes.
So my lords may then skip that portion. paragraph 5. Paragraph 5 deals with administrative delegation. May I place that, my lords? Regarding delegation of non-legislative / administrative powers on a person or a body to do certain things, whether the delegate himself is to perform such functions or whether after taking decision as per the terms of the delegation and the said agency can authorize the implementation of the same on somebody else is the question to be considered. Once the power is conferred, after exercising the said power, how to implement the decision taken in the process is a matter of procedure. The legislature may, after laying down the legislative policy, confer discretion on an administrative agency as to the execution of the policy and leave it to the agency to work out the details within the framework of that policy. So long as essential function of decision making is performed by the delegate, the burden of performing the ancillary and clerical tasks need not be shouldered by the primary delegate. It is not necessary that the primary delegate himself should perform the ministerial acts as well. In furtherance of the implementation of the decision already taken by the primary delegate as per the delegation, ministerial or clerical tasks may be performed by the authorized officers. The complexity of the modern day administration and expansion of functions of the state and economic and social spheres have made it necessary that the legislator gives wide powers to various authorities when the situation requires it. Today's governmental functions are a lot more complex and the need for delegation of powers has become more compelling. It cannot be expected that the head of the administrative body performs each and every task himself. In paragraph 6, they take note of Jalaluddin Ahmed. And paragraph 7, they discuss about practical necessities or exigencies of administration required.
4 to 10, basically.
My lords. Now, here, your lordships have already seen Rule 24B. The appointing authority is the deputy director. Then there is a committee where he is the chairman convener. So only the advertisement part has been delegated. And it has been delegated to the person who is actually at the helm of affairs of appointment. So it cannot be said that this kind of delegation is something which is not permissible. Because the rules itself say that he is the appointing authority. Those rules have been shown to your lordship. And the application also under Rule 510 has to be addressed to the deputy director. So this is a situation where the director will simply issue the advertisement under his, that's what the rule says, but the application is directed towards the deputy director. So this has to be, all that I'm trying to persuade your lordships is that a combined reading of the rules, Rule 5, 6, subclause 6, Rule 5, subclause 10, 24B would show that this is not a case of excessive delegation.
Yes.
Then the question of prejudice would come in. How are the petitioners prejudiced by this kind of advertisement? If the director issues or additional
Except for the age.
Age is an issue.
Except for the eligibility criteria in terms of age.
Yes.
That is what, according to them, prejudice their cases.
So there my submission would be, so far as age, in the second round, there was a specific prayer in prayer number 7 to relax age, and that was dealt with by leaving it to the government, and some observations were given in their favor. So that direction cannot be further now taken forward in the third round. And that prayer of theirs was rejected. So once there's
your points are no prejudice, 1, 2. What are yours?
2 is the second round writ petition prayers, and how those prayers were dealt with by in the second round writ petition is something which the Honorable Single Judge has probably missed out.
Yes.
And third is I'm relying on 3 judgments which say in the facts of this case, this kind of delegation was permissible and the deputy director could have issued the advertisement.
Yes.
And fourth point would be that the tribunal passed a specific interim order saying that if the petitioners are selected, then the persons who have been appointed subject to outcome of these OS, they will have to give way. That order of the learned tribunal was confirmed by the division bench at page 62, annexure 9. So once the division bench confirms this express direction, that if the
So what is
applicant,
the interim order? So is
interim
that-
order, my lords, my lords may kindly see the interim order of the tribunal, which would be at page 58, annexure 8.
Yes.
Now here, my lords, tribunal first passed the absolute order of stay. Then, my lords, that was modified subsequently because there was a shortage of these village agriculture workers. That modification is at page 62, annexure 9. So first order was shown to your lordships. There was an absolute stay.
What is the date?
My lords, the first order would be, first interim order is 9/12/2013. This was shown to my lords by on second one would be annexure 9 at page 62.
25/11/2014.
14. And my lord, may kindly see the submissions made by the government. 25/11/2014. That is at annexure 9, page 62.
Modified interim order.
My lords, modified interim order. Here a specific submission was made by the government that there is acute shortage of these workers in Bolangir and Keonjhar. And government programs cannot be implemented successfully.
Yes.
And on the basis of these submissions, and my learned senior, Mr. Rath, was appearing there, my lords. He submitted that learned counsel for the applicant submits that appropriate orders may be issued protecting the interest of the applicants. And on the basis of these submissions.
But Mr. Rath has been fairly submitted that there is no question of giving appointment to these petitioners, the writ petitioners. So there he accepts.
My lords, I am not joining issues with my learned senior, my lords. All that I am showing, my lords, is this interim order said that in case the applicant succeed in the OS, they are entitled to consequential appointments. Junior most of the candidates selected and given appointment shall have to make
that
way for the
interim order. That interim order is conditional. So
My lords.
unless that condition is satisfied,
my lords. So here
you
now
cannot give way to them.
that is my submission. So I am only trying to protect myself. This interim order was confirmed by the division bench at page 114 of your lordship's brief. So once this is confirmed and they are not appointed, then we should continue in our services. We are almost 11 years here. So that's what I'm trying to.
Yes.
So, my lords, all that I am submitting, my lords, that once this is confirmed by the division bench and my learned senior, Mr. Rath's clients are not appointed, then there may not be a question which may arise for removing us. And this is something probably which the Honorable Single Judge missed out, even though in the impugned judgment, these facts are recorded. It's not that these facts are not recorded in the impugned judgment.
Yes.
Well, I'm grateful to your lordship for this. These are my
Just
basic.
only add something. Let's look to the impugned order. Everything has been reflected in the order itself. Let's just 2-3 paragraphs I'll show you. Let's come to paragraph 8. In my brief at page 139, that is WA number 2974 of 2023. What was the argument advanced by the state and how it has been calculated? Para 8. Para 8 of the impugned judgment by the Honorable Single Judge. Pursuant to the order passed by this court, para 8. Pursuant to the order passed by this court on 17/7/2023, instruction in shape of an affidavit was filed on behalf of the OP number 1 and 2. Basing on the said instruction, the learned additional standing council contended that the post of VAW is a district cadre post and the OP number 1 by letter dated 22/11/2008 permitted the Deputy Director of Agriculture in respect of district to issue fresh advertisement after the advertisement issued by the Director of Agriculture on such and such day. Then we also come to page 140, paragraph 8.2. 8.2. It is accordingly contended that since the post of VW in my case, Lord, WA number 2974 of 2023. Your worship brief is 105. 2910. Also kindly 105. 8.2, yes, that one.
2910 paragraph.
8.2.
Paragraph 8.2.
Yes, 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 please. Page 105.
Yes.
It is accordingly contended that since the post of VHW is a district cadre post and subsequent to the order passed by this court on 14/8/2008, Government OP number 1 in the Department of Agriculture permitted the director to issue necessary instruction to respective deputy director of agriculture to issue fresh advertisement. And director has issued that you also have seen to the deputy director. And the advertisement has been issued by the deputy director of agriculture. There is no illegal. Then also come to the finding of the honorable single judge, that is at page 10.3. 10.3 paragraph. Page 108. Page 108. Internal page 32 of the judgment. Para 10.3, top.
Para 10.
Yes, para 10.3.
Yes.
Pursuant to the order passed by this court on 25/4/2023, it is also admitted by the opposite party that in terms of the order passed by this court on 14/8/2008, no corrigendum was issued by the Director of Agriculture and Food Production. The stand taken by the opposite party that the ground on which the advertisement dated 18/5/2008 and 5/12/2008 was passed by this court were incorporated, provided in the advertisement issued by the respective Deputy Director of Agriculture on 4/10/2013 is not acceptable, as the court in its order dated 14/8/2008, by quashing the first advertisement issued on 18/5/2008 by the Director of Agriculture, directed him to issue a corrigendum. Since the order dated 14/8/2008 was never assailed by the state opposite party, they are bound to comply with the said order by issuing corrigendum. Since at no point of time a corrigendum was issued in terms of the said order and a fresh advertisement was issued by the respective Deputy Director of Agriculture on 5/12/2008, the same was again passed by this court in order dated 3/2/2012 in WPC number so and so and that. On the face of the order passed by this court on 14/8/2008 and 3/2/2012, no corrigendum issued by the Director of Agriculture to the advertisement dated 18/5/2008. Then 10.4. 10.4, the ultimate conclusion. Since the advertisement was issued by the Deputy Director of Agriculture in respect to respective districts, including district of Balangir, in view of the provision contained Rule 5.5 of the said rule, placing reliance on such and such, the court, the considered view of this court, Deputy Director of Agriculture Balangir is not competent to issue such advertisement, and as for the rule, this nothing, no.
Yes. Anything else, madam?
They are not. More important is the order, the earlier order which Mr. Mishra had referred to, the division bench order, the consider direction was made to consider their age relaxation. That has been considered and rejected, and they have not never challenged it, and that has become final. And they cannot also, as rightly said, submitted by Mr. Roth, that their candidate, they cannot get appointed.
No, something wrong is there. I will explain.
Ground, sir.
I will explain something wrong is there, but I will get permission if I will place it.
Oh, sure.
Only two judgments I have also given. 2020-14 regarding the delegation. Two more judgments I have, and 68 Supreme.
In the REIT application, my lord, this
2020-14 SCC 345.
2020 volume
345 and 1968 Supreme Court 850. I have given copies of both the AI 1968 Supreme Court 850. I have given hard copies of
that has been relied on in this case 2024.
My lord.
1968.
Same point, but they are saying that how these exigencies of administration allow this kind of delegation. If it is an essential function which is delegated, then of course it should not be allowed.
All right.
But most importantly, the ground on which the advertisement is being impinged
that was never a ground before the Honorable Single Judge. That the competency of the director, deputy director to issue the advertisement was never an issue before the Honorable Single Judge. But the Honorable Single Judge has proceeded to scrutinize the correctness of the advertisement on the ground that it was floated by the deputy director, so therefore we see it. So, but that was never canvassed before the.
That was the challenge.
It was not pleaded specifically.
Yes. Yes, Mr. Rath.
My Lord, the Chief Justice wanted to know from me as to whether the appellants or the respondents in this appeal had made application for appointment to the post of VW or not.
Your answer is no.
No, my answer, I stand corrected, my Lord, because we applied in 2008. I have filed an affidavit, but I found that that affidavit could not be filed, though that has been shown in. We applied in 2008. By that time, we are within the age. We had the qualification. In 2008, we filed the writ application that the conditions prescribed under these service rules were not taken into consideration while selecting the candidates. That was the main crux there, my Lord. We have filed, we are in age, and we have filed. Then the Honorable Court said that the advertisement remaining intact, that provision of qualification which is prescribed is required. So there is no question of second application. The second advertisement was made, we challenged that. That was also not inconsistency to the order passed by the Honorable Court, and that was also quashed. Then, my Lord, when the third advertisement was issued by the Deputy Director, we filed an original application before the State Tribunal. There the ground was that they have not incorporated that provision. Even if that incorporated, the Deputy Director was incompetent one.
Did you raise?
Yes, my Lord. That came on transport to the Honorable Court after the abolition of the Tribunal. That was the ground, my Lord, you have taken.
Are you reading paragraph 8?
No, my Lord, I'm looking into the
grounds are taken in which paragraph of original?
My Lord, that was the original application which I am, my Lord, that I'm looking after. Because that was the only challenge before there on the London Tribunal. Because they could not have passed a fresh advertisement, and that is why that was the question. That we applied, we are in age, my Lord, that I have given by affidavit.
All of you had applied, only Sudhir Kumar Sahu?
My Lord, 4 persons. There are
the affidavit.
No, your submission, Mr. Rath, is
yes, my Lord.
That against 2008 advertisement you had applied because you fulfill the eligibility criteria in terms of age. Against 2013 advertisement you did not apply as you could not apply.
Yes, my Lord, because we are in the age. Yes, my Lord, that was uncalled for, so we could not apply.
That's all.
In your affidavit, you mentioned only Sudhir Kumar Sahu.
My lord, there are three persons. They are, my lord, they are
Where?
Bulu Panigrai,
Ulu Panigra is the deponent,
Hare Krishna.
but paragraph 1.
It was Bulu Panigrai, is it about this, my lord? See, he was petition number 1 before the London Tribunal.
Where have you stated? You gave that affidavit for our information, but where have you stated?
Now, Sudhir Kumar Sahu, my lord, he was the first applicant in 2008.
Yes, you said
But-
you had.
But Bulu Panigrai and others, they were the applicant in OL number 383989 of 2013 before the London Tribunal, which came on transfer and which is adjudicated. 3 persons were there before the London Tribunal. Bulu Panigrai, Hare Krishna Behra, and Venudhar Naik.
Yes.
They were the petitioner before the London Tribunal, in a way.
Yes. Thank you. Yes, madam.
In my case, we are
Just
only
you may
four.
leave, Mr. Acharya. Here.
No, Lord, I'm there. Let it be. Because
But in my case, we are only 4 petitioners. We are within the age 2013 we had applied, and then they have rejected our case being we were overage, because at that point of time the petitioner number 1 Nilambar Parda 33 years, and those are not within that age limit they are prescribed in the advertisement. You should born before 2002 or whatever. That's why, my lord, they have rejected our case for
So
being,
if we allow your this age criteria,
my lord.
then what will happen?
My lord, would be appointed, because there are huge vacancies are there, and this multiplicity of
The
proceedings.
vacancies which were advertised,
My lord.
whether you could have been whether you were more meritorious than the persons appointed.
My lord, that would be assessed. My lord, my submission before your lordship is that in 2008, we have been selected, and there is a letter for verification of documents. At that point of time, my lord, some persons, my lord senior was representing, came before this honorable court, then advertisement quashed. If that would be a corrigendum to the 2008 advertisement, we would have been, my lord, appointed. That is my submission. This multiplicity of proceeding and interference by this honorable court taken away our right to be appointed. And by the way, my lord, from 2008 to 2013, we are being overaged. They have treated us as overaged candidates. And it has never been stated in our case that the honorable High Court in second writ application never directed for us to consider, because we are very much within that age limit. Even if in 2013 also, my lord, we belong to SCBC category and SC/ST category, the age relaxation can be done. But they have rejected because we time and again come before this honorable court. That is the only reason. And we had selected in 2008.
Keep on coming.
My lord, that is the unfortunate part, my lord. My lord, we had selected in 2008 because there are huge vacancies available, and government can now to balance everything can appoint us also. And we are eligible, and we are vocational course holder, my lord. That's why all things.
Where is the merit list?
Yes, madam. Your lords may kindly come to WA number 2906 of 2023. Page 117 straight away. That is the
2021.
2906 of 2023. WA number 2906 of 2023.
Yes.
Your lords may kindly come to running page 117.
Yes.
Fourth name in the list, your lordship will find Nilambar Parida. Nilambar Parida. And in the very same page, down under, your lordship, another I have, it is an mark is there, asterisk marks is there, left hand side, Venudhar Shah, he is another petitioner. So both were there in the very same select list prepared in the year 2013, and their position is much below. That
4 is not much below. Fourth name is Nilambar Parida.
Hello?
Fourth is the merit position or what?
No. This is not. This is the merit position of all the candidates who were there in the fray. Out of that, the selection was made.
That means the applicants.
Well, he was the applicant. The Nilambar Parida as well as Venudhar Shah are the two applicants about whom I am referring to your lordship's query. Now, this is the part of the merit list which they have prepared of all the candidates category wise, and under that it is not in this, it is a chronological order, and in that particular page it is at serial number 4. There is no serial.
Oh, what is the
Under the, your lordship may kindly mark, it starts from the select list starts from running page 100 annexer B by 4.
All right, that is one page of the merit list.
Yes, that is
one of the pages of the merit list. In that page, the number Parida is at
serial number 4, and the other person is at serial number 14. Venudhar Shah.
Okay.
117, page 117.
Yes.
Right.
My lord, that is about the reject list, category wise, valid rejected list of applications. My lord, that is I'm saying I have applied and I am overage. That's why they have rejected.
So your
114.
application was valid, but
My lord, 114. Category wise valid rejected list. And as a SCBC mail, they have, as per overage, they have rejected. That is my case. I'm saying I'm rejected on overage. It is not in merit list. It is rejected list. Those have been rejected.
Yes. Anything?
That's it. That's it.
Lordship may close it. I think it's already.
One prayer, my lord. The Honorable Chief Justice wanted to know from Learned Advocate General whether they can be, because number is less, whether they can be accommodated or not. That let Advocate General also look into
Tomorrow we will decide. This way or that way. If in the meanwhile he
This I'll
obtains
take.
instruction, or if required, we can direct consideration of their cases.
Let me
and future
discuss
cases.
because by now, see,
No, even
they
without
Only
must be
eight,
rendered.
eight of them.
We are 4, probably they are 4 or 5.
4 only.
4.
Four
Totally 8.
8%.
So other persons may come and claim mail in that.
we will
that
see
is-
what can.
well, one
have not
correction,
filed,
my
how
lord,
can they
one
claim?
correction. She submitted that it is the rejection list, which
Yes.
is not correct, because 100 page 117, which I have drawn your lordship's attention at the top itself mentions vocational SCBC male valid candidates. Among the validated candidates, his name finds place at serial number 4. Likewise, so she is wrong in saying that it is an rejected list.
Lord,
It seldom
one,
happens. That is
Lord,
wrong.
one problem may arise, what I gather, one problem. It was for contractual appointment because the contractual system has already been abolished by this government. So it may be difficult
They'll be
because
happy
just
to
now
give
it came to my
regular.
mind. Because these are all against regular post, we have to make the regular selection. It can't be like that. So
We will see. Tomorrow.
deeply obliged.
I have filed 3 Bhaklakramas. Giving my lord.
Lord, interim order
to continue.
there
Tomorrow.
So blessed.
Sometimes
tomorrow. Tomorrow, my lords.
tomorrow to deliver the orders.
Right, you are right.
Lord, deeply obliged. Deeply obliged.
Item 46.
Minutes, I appear in 45 minutes. They go together in my humble submission.
For respondent in 45 and 46, it's a Supreme Court remanded matter.
Are you Mr. Naidu?
Yes, minutes.
Just. Yes.
I'll take your lordship through the facts so that my lords could have some orientation about the issue before your lordships, because it has come back from the Honorable Supreme Court. And then, my lords, we have got
Let
an
us see the order of the Supreme Court first.
Yes, my lords. My lords, we have filed that along with our IA. My lords could have it. What's the number of the 6467 minutes of 2024.
The lordships are taking up item 45 first.
45, yes.
In this item 45, they had filed an affidavit. I have filed a reply today, just for your lordship.
Is it there on record?
But I have just today.
Have you?
I have served copy. I have served copy.
Well, actually, your lordships have fixed this item 46 at 2 p.m. for the purpose of regularizing the matter, because I have filed 2 amendment petitions. They were pending. On the other day, when the matter was listed on my mentioning, your lordships wanted that it should be taken up at 2 p.m. today, so that the matter can be regularized and they will file counters and other things. This item 46, 3 petitions are pending. They have come up.
So the 40, right, we have not, unfortunately, we have not gone through the item 45 and 46.
In 45 and 46, kindly have a look at the Supreme Court order, then we can proceed further. So that
Yes, that will put the whole issue in perspective.
Just let us see the order first.
Yes, minutes. My lords could pick up the interlocutor application we filed.
I have otherwise also supplied
Flag
the
D.
copies of the Supreme Court's order.
Flag D minutes.
46 also.
Flag D.
Yes, minutes, I'm told. In this IA minutes, it's at page 14, 1-4. It's a shortish order.
Yes.
May I read minutes for my
Please.
lord's kind consideration?
Please.
Leave granted. This appeal arises from a judgment dated so-and-so of a division bench of the High Court of Orissa. Mahanadi Coalfields Limited issued a notice inviting tenders on 17th November 2022, inviting bids for the work of development and operation of Balabhadra OCP as per Part 2, scope of the project, of contract agreement and other requirements specified in the contract agreement for a period of 27 years. Pursuant to the NIT, 3 bidders, including the applicant, BGR Mining and Infra Limited, and another bidder by the name of NCC Limited, participated. The bid submitted by the appellant was rejected as ineligible on the ground that there was a conflict of interest amounting to a breach of the tender conditions. A notice to show cause dated 15th May 2023 was issued to the appellant. The notice specifies the objection to the bid which was submitted by the appellant in the following terms. It's also observed that NCC Limited and BGR Mining and Infra Limited are also associated through another common third party, that is Talaipalli Coal Mining Private Limited. Therefore, BGR Mining and Infra Limited has a relationship arising due to ownership, holding, cross-holding with another bidder, that is NCC Limited, directly or through common third parties, that is Messrs. Pachwara Coal Mining Private Limited and Messrs. Talaipalli Coal Mining Private Limited. In the above circumstances, it puts either or both of them in a position to have access to each other's information about or to influence the bid of either or each other, which attracts conflict of interest in line with clause number 2.2.1b. Therefore, upon scrutiny of the uploaded documents of Messrs. NCC Limited and Messrs. BGR Mining and Infra Limited, it's been observed that the uploaded bid documents are not in compliance with clause 2.21b, declaration under point number 5 of bidders covering letter and acceptance of bid conditions under clause number 2.6 of RFT. Therefore, your bid is not eligible for further evaluation as per provisions of NIT 179. Hence, the following actions have been taken as per provisions of NIT 179. As per clause 2.2.1b of RFT, bid of BGR Mining and Infra Limited has been disqualified, having conflict of interest. As per clause number 4.1 of RFT, bid of MGR Mining and Infra Limited rejected due to directly or indirectly engaged in undesirable practice as defined under clause number 4.3D. Bid security EMD deposited by the bidder, that is BGR Mining and Infra Limited, during bid's submission forfeited as the damages as per clause number 2.2.1B, 2.16.5 and 2.166 of RFB of NIT 179. Accordingly, by virtue of provisions of NIT, your bid has been rejected online in the e-procurement portal on 15/5/2023 and the EMD has been forfeited. In addition, you are liable for action under the provisions of clause number 2.16.6 and 4.2 of our RFB of NIT 179. Accordingly, you are hereby required to show cause within 10 days from the date of issue of this letter as to why the actions as per provisions under clause number 2.16.6 and clause number 4.2 of RFT of NIT 179 shall not be taken against you, failing which it would be construed that you have no valid justification. The bid of the appellant having been disqualified on the ground of a conflict of interest, the appellant instituted a writ petition under Article 226 of the Constitution. The division bench of the High Court, by its judgment dated 19th December 2023, dismissed the petition primarily on the ground that the court cannot interfere in a bid process under Article 226 of the Constitution unless the authority has acted mala fide to favor a party in an arbitrary manner. During the course of hearing, we have heard submissions of so-and-so, senior counsel appearing on behalf of the appellant, Sri so-and-so, Solicitor General, appearing on behalf of the first respondent, and Mr. So-and-so, counsel appearing on behalf of the second respondent. The bid of the second respondent was found compliant and a contract has been awarded by the first respondents. The judgment of the High Court is bereft of any reason, bearing on the grounds which resulted in the disqualification of the appellant and the rejection of their bid. The High Court has recorded the submissions of the rival parties and cited from the reasons of this court, cited from the precedents of this court. The citing of a litany of precedents does not make up for reasons unless the High Court specifically applies its mind in a case like the present to the grounds of disqualification and to the submissions which have been urged by the parties to assign them. Finding an absence of any reason in the judgment of the High Court on the merits of the issue of disqualification, we remit the proceedings back to the High Court for a fresh decision. We clarify that we have not expressed any opinion on the rival submissions, which are left open to be decided by the High Court in a reasoned judgment. We accordingly allow the appeal and set aside the judgment and order dated 19th December 2023 and restore it petition number 17120 of 2023. Pending applications, if any, stand disposed of.
So how are these two petitions connected? 45 and...
Yes, minutes. I'll explain. I'll explain minutes. Minutes when there was...
Just a minute, Mr.
Yes.
Just a minute. Yes, what do you...
Right, I am one of the bidder and they are also one of the bidders. Two independent applications were filed bidding the contract.
Same
contract.
Please.
In response to the
So you are
notice
appearing
inviting
in which
tenders.
case? You are appearing in WPC 17120.
Yes. Yes, minutes.
Please take your seat.
Millets. Insofar as the three players are concerned, Millets, when the first respondent has issued NIT, notice inviting tenders, Millets, three players responded. And two were disqualified at the technical stage. And one was accepted. And that sole bidder wanted to be awarded. That's how, Millets, that sole bidder has become respondent number 2 before your lordships. And the ones that had been rejected, one is me, the other is my learned friend, we represent. That's how, Millets, all these three players are there.
One is you.
Yes, Millets.
And the other?
My candidature has been rejected.
Yes.
So was the case with my friends. That's why we have filed 2 writ petitions, one each. And in all common parties, Millets, that's the contracting party, and Millets, the other person who participated and became the sole successful bidder.
And the successful bidder is Mr. Nataraj. No, sorry.
No, Millets.
I'm
Mr.
sorry.
Natraj represents the first respondent, Millets.
So sorry.
I'm
Yes.
appearing for
No,
this.
no. I'm appearing for the respondent company who invited the tenders, both the matters.
Yes.
Yes, it's a state.
Natarajan appears for MCL.
Yes.
It's a state
He
entity.
appears for-
Yes, yes.
I appear for the common successful vote in both the writ petitions.
Millets, to
Yes.
take your lordship through a couple of dates, Millets, I've just given a small note, Millets, because it's only a sort of an orientation. So that the issue could be.
Just 1 second, Mr. Naidu, if my friend
Yes.
is going through the merits of the case, then first there is an amendment application that has to be allowed, otherwise there is nothing to be gone.
I believe, Millets, as
There is
far
an
as my
in the
amendment,
subsequent event, which we need to file an objection, that has to be heard. It's a remanded
Millets,
matter.
my amendment has already been allowed.
There is one
I
more
filed-
amendment
So
application in
my
the other
case
matter
is
also.
concerned, the amendments are pending.
In the other one, there is.
In this
They
writ-
only incorporate
in
the
this writ
subsequent
petition,
developments.
amendment has been allowed. We have filed a count and he filed a reply. I have filed my reply to his affidavit.
That is in the first.
Yes, it
First
means
petition.
Mr. Naidu's case.
Yes.
And
No, but Mr. Natraj, because we have only 20 minutes left, we can briefly understand the issue.
Yes, very well. No, absolutely. No.
Only for that limited purpose, Millets.
And we will allow the amendments
On a par
within
with
the
whatever
other
that's.
writ applications.
Yes.
And
Mr.
we'll
Rao's
file a
amendment-
formal objection. to
Mr.
the-
Rao's amendment may be allowed.
Formal objection.
Mr. Rao's amendment may be allowed.
He wants to file or is making a formal?
Will you file any objection, Mr. Natraj? or-
No, not yet. Once the amendment is allowed, amendment to the extent of pleadings, that can be allowed. But however, we'll file a formal objection, we'll bring on record. Because new documents have been placed and subsequent event has been raised.
Yes.
Millets, as far as our writ petition is concerned, they have filed their objections also after the amendment, a comprehensive counter, including whatever we have pleaded by way of amendment. So to our extent, it's been complete, the pleadings.
That's right.
May note that in their writ petition, we are not parties. Because they are independent and,
Independent, you are also, have you pleaded in party?
no,
In your writ petition, they are not a party.
They are not parties. Therefore, what I am
They
trying to
just
say
run
is
on
that
parallel lines, Millets.
Except that it is the same tender, there is nothing common.
Millets, one chair in the musical chairs, 3 players, who will sit in that solitary chair? That's what your lordships are going to decide.
And one has already sat down.
Millets, we believe that he believed that it stood. I just had my reservations, Millets, because we could not straight away submit to your lordships.
Yes. Yes, Mr. Naidu.
Millets,
The
may I just
amendment-
pass on a short note, Millets, so that straight away I could
amendment-
take, it won't take more than 10
The
minutes.
lordship
Amendment
has been allowed.
has
So
been allowed.
there we may be given a chance to file.
You will be given a chance. We
to-
are just utilizing this time to understand the
That's-
basic
that's-
issues involved
This
because
is the first writ
because
petition.
you understand. So many stalwarts are bearing. So therefore,
No,
But there is one more small request, amendment only with regard to the pleadings, because in the same application, they have sought for amendment of the pleadings and also sought for one interim relief. To that extent, that cannot be granted, only the amendment of the pleadings, nothing else.
And naturally, interim relief we will not grant without hearing you.
no,
No,
amendment we
because
will allow.
allowing of
only.
the application, please see the prayer, there are 2 prayers.
Just a minute. Just a minute.
Yes.
Let us look at the application.
in the same petition, they have made 2 prayers.
Oh,
In the same petition.
Millets, what's been allowed is an amendment when it comes to prayer, which is
Initially, we
substantial.
have filed an application for amendment, incorporating the subsequent developments, that is the so-called notice, reply and all those things. After
Right.
the Supreme Court's order,
Which is that?
you file another amendment
Yes,
application. There
yes.
you prayed for interim relief.
no, there I have said that Honorable Supreme Court has already set aside the order, and therefore the earlier interim order to pending.
At page number 5 of the application.
And perhaps your lordship should be called upon to decide an interesting question in my humble submission. That is, all through there was interim protection for both of us when the writ petition was pending. Now it's been remanded and the writ petition stood restored. Then, does that mean, Millets, in my humble submission, the earlier orders continue, or should there be a further essay on my part to convince your lordship there is a prima facie case? And Millets, there is a judgment by the Honorable Supreme Court that Farid Jacobs case, Millets. In that one, it is 2:1, Millets. And the majority has held that once even when it comes to an injunction or any sort of interim protection and dismissed for defaults, once it's been restored,
That is-
automatically they get
That
restored.
is, this amount.
Yes, my lords.
Almost to restoration of the original.
Precisely. So in that sense, my lords, whatever the IA we have filed, it's out of abundant caution. We have already been protected by your lordships, and that order continued until the dismissal of the writ petition. Now that order having gone, everything has sprung back to life, in my humble submission. Anyway, I'll just show that if at all the need arises. But before that, my lords, I'll take your lordships to the facts of the case.
Mr. Naidu, we are hearing the same writ applications which were filed. against
Indeed, my
this-
lords, barring one change, incorporation of the subsequent development that happened in the interregnum of the dismissal and the setting aside by the Supreme Court. That's the only change, my lords, a couple of months. And that development has been brought on record.
Where is your IA for amendment? IA number flag 10, 20055.
That is the subsequent application. The earlier one is flag D.
Flag D.
Flag D.
When did you file?
16276 of 2020.
16276 of 23. Flag D. No, there is another amendment. Yes.
Yes, Mr. Nataraj, do you have any objection to this IA 162?
Insofar as pleadings are concerned, I don't think I can object. I am not objecting.
Number.
Pleadings are concerned, definitely kindly allow it.
WPC 17188 of 2023. IA number 16276 of 2023. Both these writ applications have been taken up together.
This is 6495.
Which have revived in the light of the Supreme Court's judgment dated.
In my case, that is
26th April 2024.
no, in my case, that was in 6/5/24. With same order, but then it was on 6/5.
Order dated
6/5/2024.
26/4/2000.
No, no, six,
that is
only
the
6.
earlier one. And this is 6/5/2024.
The order in the Supreme Court order in WPC 17188, the Lordship can get in IA number 6495
6/5/9.
at page as annexure 1.
No, for NCC Limited, it is 6/5/2024.
NCC is 6/5/2024.
Yes.
It's also which reads as under. Stop. As both the writ applications arise out of the same tender, same bidding process, they have been taken up together. Stop. IA number so and so in WPC number 1788 of 2023 has been filed 16276 of 2000, seeking amendment in the writ application in view of developments subsequent to filing of the writ application, so as to incorporate additional facts. Stop. Considering the nature of amendments sought, comma, IA number so and so is allowed. The petitioner is granted leave to amend the writ petition by incorporating the averments, contentions and documents as set out in the schedule to the application. So stop. Which is the second one?
Second one is at flag 11.
Flag, no, not flag 11. Flag 11.
Yes.
171.
No,
Yes, Mr. Nataraj. This.
Yes, in the second application 6594, first prayer can be allowed. There is no problem. It's amendment.
994.
But there is a second prayer. Only to that extent we have reservation or objection.
Just.
Please see the prayers.
So for amendment is concerned, it can be
649.
allowed as per my letter.
This application
Second
has
prayer is
been
not
filed.
necessary.
Not necessarily.
Not necessary.
Yes, as my husband is submitting.
What's the second prayer?
Second page to
Page
continue
five.
the entry mark.
Page 5 of the petition.
This application has also been filed for seeking amendment in the writ application as per the schedule of senior counsel appearing on behalf of the petitioner has submitted that the shall press the interim relief later. Yes, Mr.
Yes.
You are not pressing that for the present, you will press that later.
Press that later.
Later.
For the present.
Very fair.
Accordingly, prepare for to the extent the same relates to amendment in the writ application. Stop. Then, in the light of the amendments allowed by the present order, let a consolidated writ application, writ petition be filed.
There is one more application at flag E.
Filed on behalf of the petitioner. Why?
Within 3 days.
But isn't that part of the amendment?
Yes.
Isn't that part of the
No,
amendment?
that's not the part of the amendment.
How can you add documents if it is not part of the amendment?
Well, that is what has happened, Miller. On a similar clause, was introduced by the.
That he's asking for acceptance of additional documents unless it is part of the amendment. How can you accept this letter?
So document is not part of your IA.
Another IA.
Separate IA.
There is another IA.
Third.
That is not an amendment.
I said that subsequently they have issued another tender in a similar clause.
So you make an amendment application to bring on record those documents.
Yes. That can be.
That you can do, or you can file additional affidavit as you want.
That can be. Your lordship may treat that as also an amendment to incorporate.
Yes, but where will that be added?
Another election. I will give it.
List these matters on. Any other order? We pass today.
We'll file our counters to the.
List these matters on. List these matters on. When?
Your lordship may give us
May I-
2 to 3 weeks.
May I
time.
humbly pray one thing, Millets? Any Wednesday, Millets, next Wednesday.
No, we'll file.
Even my friend Mr. Natraj could endorse that one because that could be the day
Wednesday,
we can come down physically.
All right. Wednesday.
No, Wednesday, Thursday would be very fine, as Mr. Naidu said, but a small request. Since amendment has now been allowed, I think they may have to file at least some formal objection to the amended petition, because some new developments, new documents have been brought on.
Yes, you will have.
So at least some time has to be given.
Some time.
How much? Therefore, it's just
Whatever reasonable, any reasonable time, 2 weeks.
Your lords may fix up this case on 25th And in the meantime,
Let the
pleadings
pleadings
can
be
be
completed.
completed.
Minutes.
All these things can be completed.
That could be
25th
fair
is
proposition.
not too
25th.
Too short.
25th, 2 weeks
No,
they
no,
were
for
saying.
filing the objection or
No, no,
consolidated
filing,
objection.
everything can be in between.
Today is 10th. Yes, you can, that can be done, 25th.
25th.
This will be.
Simplify.
All it is, 25th. These matters on 25th.
Great.
In the meanwhile, let the parties file their counter pleadings. Counter pleadings, therefore, counter pleadings, whatever you want, counter pleadings. Slash a reply to such pleadings. So it is also expected that counsel appearing on behalf of the parties shall exchange the pleadings in the meanwhile. From 25th to be taken up at 2 p.m.
Grateful minutes. May just as a last indulgence minutes for this day, kindly have a look at the judgment for each Jacob minutes. That they stand restored, the whole rigmarole of considering an IA would be obviated.
Mr. Nataraj, in any case, the situation that was existing just prior to the date of passing of the order of this court will have to be maintained.
No, that may not be in all situations. You know, the subsequent development of awarding the contract, which has been taken note of by the Supreme Court, still it did not grant the interim order. That would be the situation.
Well, that's a lispendence development which has fallen to the ground with the reversal.
No. All right. Let it come on 24th. We will see. Then, at least you maintain a status quo.
So be it. That's
no. The work is already
indeed the need
awarded.
Work has been awarded.
No, Millets, I'll just correct it, Millets. My lords may kindly appreciate, based on the records, not otherwise. Millets, once the work is to be awarded, there is a cooling off period of 360 days, gestation period, where the first respondent has to take all the necessary statutory permissions.
Work has been awarded to who?
Millets, the second respondent before your lordships. Millets, once the writ petition was dismissed, Millets, once the writ petition was dismissed, immediately we have gone before the Honorable Supreme Court and filed an SLP. Pending that SLP, they have awarded the work. At least they have issued the proceedings. Now, Millets, immediately we have sought the amendment. That's letter of acceptance that's been given, Millets. We have sought an amendment. We have also filed an IA with regard to incorporating all those things. Now, Millets, what has happened there? It's been reversed and things have been set at the very initial place where they have been. Now, Millets, this is being a lispendence development, cannot have legs to stand on.
We will see.
So be it. Yes.
In fact, on the date of dismissal of the writ petition itself, I have filed an application to suspend the judgment because we are going to Supreme Court.
Millets. For that purpose, Millets may pray, Millets, status quo may have to be observed. Millets. It leads to otherwise in my respect submission.
On the interim order, we are not saying.
So be it. Let it be on 25th. 25th. Grateful, Millets, deeply obliged.
Item number 56.
My lord, the petitioner, the lordship remembers, my lord, it is about that two clauses about the additional performance security.
Your lordship, item number 56, your lordship, as per urgent, your lordship, due to mother land DSI expired, your lordship.
What?
Mother of the land DSI expired, your lordship.
My lord, the mother of London DSI has
is also absent, your lordship. 1 week after your lordship press.
But he is conducting the case of Mr. Kashyap.
My lord.
Your lordship.
My lord, today we are filing the counter, man. Counter is already on record. It's a hard copy of the counter, man.
Filing is.
Man.
When should we take up the matter?
One after any date, your lordship.
Huh? 1 week, Mr. On the ground of bereavement in the family of land counsel representing the opposite party. An adjournment is being sought. Stop. List this matter on 1 week. Taken up at 2 p.m.
Interim order.
Interim orders that continue in the meanwhile. Yes. Yes.
Item 37.
Item 37, your lordship, is for withdrawal on behalf of Mr. Abhijit Patnaik.
Yes. Yes, madam.
My lord, item 41. Can we have it at 2 p.m. for my lord?
2 p.m.
My lord,
Just a minute. Just a minute.
my lord, item
Please.
Or any other day, my lord.
Tomorrow. What is your
Tomorrow or
agenda?
any other day this week.
On the
As
other
per
day.
lordship's convenience.
Next week then?
Next week or date might be fixed.
my lord, item 60.
At 2 p.m.
My lord, item 60 pertains to NEET admission, NEET UG matter.
Item?
60 may be taken up tomorrow, otherwise it will.
Tomorrow make a mention.
Item
Tomorrow make
36.
a mention at 2 p.m. We will try to take up the matter if the matter is urgent at 4 or something.
Always,
All right.
always.
Just make a mention. If the matter is so
Will
urgent, we will take up, we will try to do.
My lord, item number 35, I was facing a small accident, so I cannot attend on time.
35.
35.
It has not
All
been
right, you
called.
should be happy
It has not been called.
that we are slow. We could not take up your matter.
Item
Yes.
tender matter.
What happened?
Single. Item 26, tender matter, single bench has already granted an interim order. Now the writ petition becoming infructuous. Matter. The lordship had 3 eyes this matter. 26, single bench granted interim order, a tender matter. By virtue of that interim order, he is continuing. Meantime, the writ petition becoming infructuous.
Then what is the problem? There is no problem.
My lord, he is continuing. His term is over by virtue
Then
of that.
how are you saying it is infructuous?
My lord, I am for the opposite.
My lord, 2 writ petition has been filed.
My lord already had, my lord, on that date, my lord, order reserved.
Yes, order will be dictated.
I had order reserved, but it has come for orders.
All right, all right.
Because we have
Your,
directed
how
it
many
to
matters
be
are there? 2?
2, my
2 tomorrow. First 5 guesses. Tomorrow we will take up your matter.
Item 54, my lord.
Yours.
My lord, item
what?
54.
And you don't worry about your case.
My lord, item 54, my lord.
and fixed for judgment matter. Item 36, the tender matter.
That is another one.
OSMCL tender matter.
All right.
My lord, item
tomorrow.
57. My lord, item 57 may be taken tomorrow.
All
Make a mention tomorrow.
Item
Matter is urgent. What is the matter about?
Matter about a tender matter for payment.
All right.
I mean, item